welcome back to Morbid Sunshine. I today have a full interrogation of Jeffrey Epstein. I am going to come back on and do all the paperwork as well. I hope I don't get a copyright strike for this, but I wanted to record it before it was taken down. Thank you for at Willora for posting this, and I appreciate anything. And as soon as it is dropped, I do record it because it is taken down straight away. It's to get the message out there, and I get that. And please don't take it for granted. Watch it all the way through. Thank you.
Good morning. We're now on the video record. Today is Wednesday, the 17th day of February 2010. The time is 11:16 a.m. We're here at U.S. Legal Support, 444 West Railroad Avenue, West Palm Beach, Florida. This is the videotape deposition of Jeffrey Epstein, taken by the plaintiffs in case number 502008CA028051MBAB. The matter of L.N. versus Jeffrey Epstein, filed in the 15th Judicial Circuit in Palm Beach County, Florida. Court reporter is Terry Becker of U.S. Legal Support. The videographer Joe Rogan of U.S. Legal Support. Would all counsel please state their appearance for the record?
Brad Edwards on behalf.
Mr. Jaffe.
Mike, Stephen Jaffe.
Michael Pike on behalf of Jeffrey Epstein.
Please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am. Can you give us your name?
Jeffrey Epstein.
Mr. Epstein, you made a comment when you came in the room that you were appreciative of me being respectful to your housekeeper yesterday, and I intend for that to be the same with you today. I want to start by asking you, at this point, we've gone through a lot of discovery in this case. There aren't many disputed facts as to what actually happened at your house. And generally, I think you would agree that you devised a way for young females to come to your house and engage in varying degrees of sexual activity. Some of the girls as young as 12, some of them as old as 17 or so, most in between. But as of yet, you haven't provided an explanation. So I want to provide you an opportunity to tell the jury at this time why you did it.
I'm going to object to confusing, compound, and irrelevant as wording.
I'd like to answer that question, frankly. However, at this time, my attorneys have told me that I can't, and I must invoke my 5th, 6th, and 14th Amendment rights, or I risk losing their counsel. Accordingly, I therefore assert those rights. Sorry.
And in addition to that, I'm going to move to strike counsel's statement as narrative as well.
I understand. We wanted to provide him the opportunity if today was going to be the day.
Same thing, move to strike narrative.
Mr. Epstein, how long have you been sexually attracted to underage minor females?
Objection, harassing, argumentative.
Are you kidding?
No, I don't feel like I'm divulging any secrets here, right?
Move to strike.
No, that's the question.
I'd like to answer that question as well, like all your other questions today. However, I have to follow my attorney's advice. They have told me that I must invoke my 5th, 6th, and 14th Amendment right to not answer those questions today or any questions relevant to this lawsuit. So accordingly, I'm going to assert those rights, and under the Constitution is guaranteed by the 5th, 6th, and 14th Amendment.
Okay. Would you consider yourself addicted to sex with minor females?
Same objections.
Mr. Edwards, I want to be very respectful. And as the current U.S. Attorney has described your law firm as a criminal enterprise and part of one of the largest frauds in Florida's history, it's been reported that your firm has fabricated multiple cases against me in order to fleece unsuspecting investors out of millions and millions of dollars. So unfortunately, at this time, though I'd like to answer that question, on advice of counsel, I'm going to have to refrain and assert my 5th, 6th, and 14th Amendment right.
And you think he's explaining that the reason he's restricting his rights is because of the corruption in the force, or that, like, what's going on, that his investors are getting fleeced, and that is not what he asked. He's not asking about that. So why, don't understand.
You then provide an explanation for what relevance that soliloquy of yours has to whether or not you engaged in sex acts with she was a minor.
Objection. No, he cannot. Argumentative. Compound. Harassing.
Mr. Pike, with all due respect, it wasn't my idea for him to give this speech about a former RRA law firm. I'm just asking him, elaborate on that.
Counsel, I'm working with your follow-up question. So I'm objecting, and I'm objecting to form, and stating the reasons on the record as to why the form is required to be objected to based upon your question.
Will he elaborate on the relevance of that soliloquy to his touching when she was 13, 14, and 15 years old in a sexual manner?
I'm going to object again. Argumentative, compound, harassing, and irrelevant as worded.
Why does he keep coughing at certain points as well? That's a bit freaky, you know.
You can answer.
I'd like to answer. However, I'm going to have to assert my Fifth Amendment, Sixth Amendment, and 14th Amendment right, as advised by my counsel. Otherwise, I risk losing their advice.
Mr. Epstein, have you ever been diagnosed with a sex addiction to minors by a psychologist or other medical professional?
I intend to respond to all your questions at some relevant time. However, today, at the present time, my attorneys have counseled me that I cannot provide answers to any questions relevant to this lawsuit, and I must accept their advice or risk losing my Sixth Amendment right to effective representation. Accordingly, I assert my Fifth, Sixth, and 14th Amendment rights to the United States Constitution.
In addition to that, Mr. Edwards, as the court has ruled in several matters, Mr. Epstein's medical history is not relevant at this time, nor has he placed same at issue in this case.
Understood. Mr. Epstein, were you sexually abused as a minor?
Again?
Were you sexually abused as a minor?
You know, I'd like to respond to all your, if any, questions seem to be relevant, but I would like to respond to any relevant question at this time. However, my attorneys have counseled me that I cannot provide answers to the questions relevant to this lawsuit today. I must accept their advice or risk losing my Sixth Amendment right to effective representation. Accordingly, then, I assert my Fifth, Sixth, and 14th Amendment right to the United States Constitution.
Isn't it true that you have engaged in some sexual interaction with hundreds of underage minor females in the last 10 years of your life? Is that true?
Objection, relevance.
Mr. Edwards, the current U.S. Attorney has described your law firm as a criminal enterprise and part of the largest fraud in Florida's history. It has been reported that your firm fabricated multiple cases, many multiple cases against me in order to fleece unsuspecting investors out of millions and millions of dollars. Unfortunately, at this time, in response to your question, my attorneys advised me that I must assert my Sixth Amendment, Fifth Amendment, and 14th Amendment right. Though I believe you know that I would really like to answer your questions today, but at this moment I must assert those rights or risk having my attorneys resign.
You're invoking your Fifth Amendment rights to each of these questions because you know that your answers will incriminate you and you feel that it will result in you being prosecuted for these crimes. Isn't that right?
Objection, argumentative, harassing, and calls for a legal conclusion.
No, in fact, the Supreme Court recently said that the Fifth Amendment right is there to protect the innocent. So that's the way I'd like to answer that.
Are you actually telling the jury that you didn't commit the crimes that have been alleged against you by the various females that were underage when you engaged in sex with them? Are you telling the jury that right now?
Objection, argumentative, harassing.
I would like to respond to that question, as you know. However, at the present time, my attorneys have counseled me that I cannot provide answers to any questions relevant to this lawsuit, and I must accept their advice or risk losing my Sixth Amendment right to effective representation. Accordingly, I assert my Fifth, Sixth, and 14th Amendment right under the United States Constitution.
Mr. Epstein, you understand that this is the video that will be played to the jury in trial against you, and wants answers. The jury is going to want answers. So I know that you're telling us that you're going to respond at some time in the future, but the time is now. Would you like this opportunity to explain why you engaged in sexual activity with beginning when she was 13 years old and you were 50 years old?
I'm going to object once again. We're getting way too argumentative with the questioning. The questioning is compound, it's speculative, and it's also harassing. Whether or not this deposition video thereof is played in front of a jury is a question of fact, and it will be.
What's strange to me is that, like, this relationship he's talking about, could it be the Danan family, or I can't remember the name, but he was going to marry their daughter or something like that, and it was just one of his first girlfriend's daughters in the pictures and stuff like that, and I'm wondering if they're talking about that.
Determined by a judge pursuant to a motion and limiting various portions thereof may or may not be played. So, having placed those objections on the record, I'm going to instruct Mr. Epstein not to answer that question.
Mr. Pike, I don't know if you watched the 13 hours of harassing questions to Miss that she sometimes invoked her Fifth Amendment rights, and I understand the adverse inference that will be given. And she was made to answer these questions, and these exact same questions were asked of her. In fact, I'm using the phraseology from Mr. Ludier. I'm not trying to harass him. I'm simply asking him to explain to the jury, if you're saying that it didn't happen, say it didn't happen. If you're saying it did happen, explain to the jury why you did it. That's all we want to hear. I'm being respectful about this.
In an effort to keep a clean record and be respectful to the co-reporter, and rather than have a diatribe back and forth between you and myself, I'm going to move to strike your last statement as irrelevant. Let's move on.
Mr. Epstein, is it true you were born January 20th, 1953?
Yes.
Where?
New York.
Where in New York?
Brooklyn.
Did you go to high school there?
Yes, sir.
Where?
Lafayette High School.
After high school, did you attend college?
Yes, sir.
And where was that?
New York.
What college did you attend?
Cooper Union.
I'm sorry.
Cooper Union.
And did you get a degree from Cooper Union?
No, sir.
How many years were you in college?
I believe 2.
What'd you study?
Physics.
And why did you leave college early?
I intend to respond to all relevant questions regarding this lawsuit. However, at the present time, my attorneys have counseled me that I cannot provide answers to questions that may be relevant to this lawsuit. So accordingly, I assert my constitutional rights as guaranteed by the 5th, 6th, and 14th Amendment.
By you invoking your Fifth Amendment rights as to why you left college, is it safe then to presume that that answer you believe would incriminate you in some way?
Okay, I'm going to move to strike speculative, argumentative, harassing, calls for a legal conclusion, and I know exactly what you're trying to do here, Mr. Edwards, is lace the record with questions that would ultimately give you an adverse inference at any potential trial of this matter. So, having put that on the record, I'm going to instruct him not to answer that question based upon his 5th, 6th, and 14th Amendment rights to the United States Constitution.
With all due respect, you cannot invoke his Fifth Amendment rights. Your attorneys instructed me in that fashion.
He can.
And Tatum Miller. had to do it herself. So I'd like to hear it from Mr. Epstein. Can we assume that by you invoking your Fifth Amendment rights as to why you left college early, that that answer you feel would incriminate you?
Once again, move to strike for the same reasons. You can.
I've already answered the question, but I'll restate the answer if need be, which is I intend to respond, and I'd like to respond to all your questions today. However, my counsel has advised me that I must take the 5th, 6th, and 14th Amendment right as under the U.S. Constitution.
Okay. After college, where were you employed?
I'd like to respond to all your questions today. However, as advice to counsel, I intend to take the 5th, 6th, and 14th Amendment right as provided by the United States Constitution or risk losing my counsel's representation.
Well, isn't it true that you were a teacher at the Dalton School in New York after college?
Again, I would like to respond to all your questions. However, my attorneys have counseled me that I cannot provide answers to any questions today regarding to this lawsuit. So I must accept their advice to risk losing my 6th Amendment right to effective representation. Accordingly, I assert my constitutional rights as guaranteed by the 5th, 6th, and 14th Amendment to the Constitution.
Mr. Epstein, did you have sex with any underage students while teaching at the Dalton School?
Could you repeat that?
Yes. Did you have sex with any underage students while teaching at the Dalton School in New York?
Mr. Edwards, your firm has been described by the U.S. Attorney as one of the largest, as a criminal enterprise, perpetrating one of the largest frauds in Florida's history. It has been reported that your firm fabricated multiple cases against me and others in order to fleece unsuspecting investors out of millions and millions of dollars. Unfortunately, at this time, in response to your question, my attorneys have advised me that I must assert my 6th Amendment, 5th Amendment, and 14th Amendment rights. Though I believe you know I'd really like to answer your questions, but at this moment I must assert those rights or having my attorneys resign.
Mr. Pike, I think you know that he has a couple options here. He can answer questions or he can invoke his Fifth Amendment rights. This non-responsive verbiage regarding the RRA law firm is not one of the options. It's inappropriate in a deposition, and I'd ask that you instruct your client not to obstruct this process any further. I'm not going to terminate the deposition. I want it to finish. But obviously, this is going to be the subject matter of some motion in the courts, and you know that the judges are not going to appreciate this. So I'd like it if we can just move this process along by eliminating that portion of his answer. I understand what he's saying. I get it. But that's not something responsive to any of these questions, and I think that you know it's inappropriate.
I think the deponent is answering the questions. So if you believe that the responses are inappropriate, I feel that you can take it up with the court with the motion that you're speaking of, as you've done several times before.
After leaving the Dalton School, is it true that you began working as a money manager at Bear Stearns?
I intend to respond to all your questions regarding this lawsuit at some relevant time. However, at the present time, my attorneys have counseled me that I cannot provide answers to any questions relevant to this lawsuit. Since the U.S. Attorney has described your law firm as a criminal enterprise, Mr. Edwards, and a part of the largest fraud in Florida's history, I am going to assert my 6th Amendment, 5th Amendment, and 14th Amendment right as under the U.S. Constitution.
I'm not sure what year this could have been if Trump was in Parliament then. Oh, what? And I'm sorry if you keep thinking that I'm starting, but I don't want to be copyright strike for this. I want it to be up there. And if you want to see it all the way through, I'm going to put it on my Patreon tonight. Probably for about £2, all the interviews. So it's up to you.
Isn't it true that while you were working at Bear Stearns, you were already engaging in sex with underage minors?
Again, I believe you know the answers to those questions, but
Yes.
excuse me. May I finish?
Move to strike. Let
Sure,
the
if you're
witness,
gonna
let,
take
let the
take
witness,
the
let the
fifth.
witness answer your question.
I would love for him to answer your questions.
Mr. Edwards, as you know, there are serious Fifth, Sixth, and 14th Amendment constitutional rights at issue here, and the witness is attempting to answer your questions to the best of his ability, despite how laced they are with adverse inference presumptions.
I don't want the adverse inference. I want answers. That's it.
So,
I want these adverse
having said that,
inferences.
please allow the witness to answer the question.
I will.
Okay. Could you repeat the question?
Isn't it true that while working at Bear Stearns, you were already engaging in sex with underage minor females?
As your firm has been described as by the U.S. Attorney as a criminal enterprise, using some of the cases fabricated against me personally, I would like to answer that question today. However, on advice of counsel, I must assert my Fifth, Sixth, and 14th Amendment rights under the U.S. Constitution, or in fact, risk losing their representation.
At some point in time while at Bear Stearns, you met and managed the money for a fellow named Leslie Wexner, correct?
Again, I would like to answer all questions relevant to this lawsuit, but today I must exert my Fifth Amendment, Sixth Amendment.
I mean, where is Wexner? I mean, he was also had ties to the mob, and to be honest, he's not been really interrogated or anything as far as I'm aware. Nobody seems to be mentioning Wexner, but he had a relationship with Epstein, an inappropriate relationship. You're also hearing now about, through Riley, about these parties, you know, and I feel Epstein could have been a young boy who possibly was, you know, broken into this lifestyle. I am still unsure, but I don't know.
And 14th Amendment right under the U.S. Constitution.
In fact, I read in another deposition of yours that you do not consider yourself to be homosexual, correct? You've answered that question before.
Correct.
Do you consider yourself to be bisexual?
No.
Okay. In any event, you did develop a sexual relationship with Leslie Wexner at some point in time. Is that true?
No.
Okay. Did you have a business relationship with Mr. Wexner?
I intend to respond to all relevant questions. I'd like to answer most of your questions, Mr. Edwards, today. But however, especially since your firm has been described by the United States Attorney in South Florida as a criminal enterprise purported to have pulled off the largest fraud in Florida's history, I would like to answer that. However, my attorneys today counsel me that I must assert my Fifth, Sixth, and 14th Amendment right under the U.S. Constitution, and therefore I'm going to do that.
Are you saying that because Rothstein Rosenfeld Adler was determined to be a criminal enterprise, or somebody was running a criminal enterprise out of that law firm, that is the reason why you're not going to answer these questions today? You link that together in that answer. I just want to make sure I'm understanding that right.
I'm going to take the Fifth Amendment. I intend to respond to all relevant questions today. I would like to respond. Unfortunately, my attorneys have counseled me I can't. I must assert my Fifth, Sixth, and 14th Amendment rights under the U.S. Constitution.
Because other law firms have asked very similar questions, and you haven't responded to any of theirs either. So I just want to understand what the relationship between Rothstein Rosenfeld Adler is to you invoking your Fifth Amendment rights today. If you can articulate that for me.
Form compound argumentative.
Rothstein Rosenfeld Adler has been described by the U.S. Attorney as a criminal enterprise, and as part of the largest fraud in Florida's history, it has been reported that your firm fabricated multiple cases using me and against me in order to fleece unsuspecting investors out of millions of dollars.
Another longtime friend of yours is Ghislaine Maxwell, right?
I can actually believe that it come to a point with him that he was so good at what he did that it possibly could have pissed Trump off. And he's thought, hang on a minute, he's putting all these in dividends through his island and partying them off through the Virgin Islands law. And when you read up about the statements that have been made in the island that dealt with the case, there's billions and billions of pounds that he's invested into these companies that are still existing. You know, so we'll dive into all these things being mentioned today as well.
I intend to respond to all relevant questions. I'd like to answer most of the questions today, but I can't because my attorneys have counseled me that I cannot provide answers to any questions relevant to this lawsuit. And I must accept their advice or risk losing my Sixth Amendment right to effective representation. Therefore, I'm going to assert my constitutional rights under the Fifth, Sixth, and 14th Amendment. Excuse me, could we take a break?
Already?
Just restroom. Yes?
Going off the video record at 11:38 a.m.
Thanks.
We're back in the video record at 11:48 a.m.
How did you meet Ghislaine Maxwell?
I intend to respond to all relevant questions to this lawsuit. However, at the present time, my attorneys have counseled me that I cannot provide answers to any questions relevant to this lawsuit and must accept this advice or risk losing my right to effective representation. Accordingly, therefore, I assert my Fifth, Sixth, and 14th Amendment right to the U.S. Constitution.
You would agree, would you not, that Ghislaine Maxwell shares your sexual obsession for underage minor females?
Argumentative, speculation, harassing.
You know, Mr. Edwards, the current U.S. Attorney has described your law firm as a criminal enterprise as taking part in one of the largest frauds in Florida's history. It has been widely reported that your firm fabricated multiple cases of a sexual nature against other people and me in order to fleece unsuspecting investors out of millions of dollars. So unfortunately, at this time, in response to your questions, my attorneys have advised me that I must assert my Sixth Amendment, Fifth Amendment, and 14th Amendment rights. Though I believe, as you know, I'd really like to answer your questions, but at this moment, I must assert those rights or risk losing my attorney or risk losing effective counsel. I intend to respond to all relevant questions regarding this lawsuit. However, at the present time, my attorneys have counseled me that I cannot provide answers to any questions relevant to this lawsuit. Your firm has been described as a criminal enterprise as part of the largest fraud in Florida's history, fabricating sexual cases against me and others. Therefore, unfortunately, though I'd like to answer all of your questions today, I'm going to have to assert my Fifth, Sixth, and 14th Amendment right.
Did you and Ghislaine Maxwell sexually assault at Leslie Wexner's house?
I intend to respond to all relevant questions regarding this lawsuit. However, at the present time, my attorneys have counseled me that I cannot provide answers to any questions relevant to this lawsuit and must accept this advice or risk losing my Sixth Amendment right to effective representation. Accordingly, I assert my constitutional rights as guaranteed by the Fifth, Sixth, and 14th Amendments to the U.S. Constitution.
Mr. Epstein, Ghislaine Maxwell and you have devised several schemes to lure underage girls to you for sex. Isn't that correct?
Form, argumentative, harassing.
Mr. Edwards, your firm has fabricated multiple cases, sexual harassment claims and other types of sexual cases against me and others in order to be part of what the U.S. Attorney described as the largest fraud in Florida's history. I'd like to answer all your questions. However, my attorneys have counseled me that at least today, I must assert my Fifth, Sixth, and 14th Amendment rights under the U.S. Constitution.
Do you own a home in Manhattan?
I I intend to respond to all relevant questions to this lawsuit. However, at the present time, my attorneys have counseled me that I cannot provide answers to any questions relevant to this lawsuit, and I must accept their advice or risk losing my Sixth Amendment right to effective representation. Accordingly, therefore, I have to assert my Fifth, Sixth, and 14th Amendment right under the U.S. Constitution.
Do you own an island in the U.S. Virgin Islands?
I intend to respond to all relevant questions regarding this lawsuit. However, at the present time, my attorneys have counseled me that I cannot provide answers to any questions relevant to this lawsuit, no matter how much I'd like to. Therefore, I must accept their advice or risk losing my Sixth Amendment right to effective representation. Therefore, I have to assert my Fifth, Sixth, and 14th Amendment right under the U.S. Constitution.
Do you own a home in New Mexico?
I intend to respond to all relevant questions regarding this lawsuit, and as I've had to do with most of your questions here today, I'm going to have to take my attorney's advice and assert my Fifth, Sixth, and 14th Amendment right under the U.S. Constitution, or risk losing effective representation.
Is it true that you have had underage females at each of those homes for orgies with you and Ghislaine Maxwell?
Form argumentative speculation and harassing.
Well, I would like to answer that question. I really would. However, as your firm has been described by the U.S. Attorney as a criminal enterprise, its principal purpose was racketeering conspiracy to generate money for the firm and its co-conspirators through the operation and enterprise and through various activities including mail fraud, wire fraud, and money laundering, and fabricating multiple sex cases against me and others. Though I'd like to answer your question today, Mr. Edwards, my counsel has advised me I must take the Fifth, Sixth, and 14th Amendment right as provided by the U.S. Constitution.
You know somebody named...
Would you spell that for the record?
No.
Or for the court report?
You don't know the name?
No. Could you spell it? Okay.
Did your sexual obsession with underage minor females grow at some point in time to allow you access to these underage minors every single day for sex?
Overbroad, speculation, argumentative, compound, harassing, and confusion. Confusing as worded. You want to break it down, Mr. Edwards?
Isn't it true that for the past 10 years, you have found a way to engage in sexual conduct with underage minors on an everyday basis?
Speculation, argumentative.
As your firm has been described as a criminal enterprise by the United States Attorney and as part of the scheme to defraud people in South Florida of millions of dollars, you have fabricated sexual cases and sexual claims against people like me and others. Unfortunately, this time, though I'd like to answer your question, Mr. Edwards, my counsel has advised me I cannot. And they've advised me I must assert my Fifth, Sixth, and 14th Amendment rights under the Constitution.
Isn't it true that you have promised underage minors money or other benefits to engage in sexual conduct with you over the past 10 years?
Again, as I've answered many of your questions today, and unfortunately I'm probably going to end up answering most of your questions today, as your firm has been described, the firm bringing this lawsuit, I believe, has been described, and if I'm wrong, please correct me.
You're wrong.
Okay. This is the firm that didn't notice this deposition
Did not.
originally?
No.
Okay. Did not notice?
Right.
I apologize. So your former firm has been described And the person you represent, Tatum Miller, in this case, was represented by the firm that was described by the U.S. Attorney as perpetrating one of the largest frauds in South Florida's history, fabricating multiple sexual cases against me and others in order to fleece unsuspecting investors out of millions and millions of dollars. So though, unfortunately, I'd like to answer each one of your questions today, my counsels advised me I must assert my 6th Amendment, 14th Amendment, and 5th Amendment right. Though I believe you know I'd like to answer those questions, but at this moment I must assert those rights or risk losing my attorneys.
Sure, let's test that answer. Let's talk about Jane Doe 102. Jane Doe 102, who was represented by Bob Josephsberg's firm, Podhurst Orsak, had nothing to do with Rothstein, Rosenfeld, Adler. Do you know?
So she's, again, who? Can you spell it?
Common spelling. Like.
Can you spell it for me, please? How's it? What's the last name? How's it spelled?
I believe.
I intend to respond to all relevant questions regarding this lawsuit. However, at the present time, my attorneys have counseled me that I cannot provide answers to any questions that may be relevant to this lawsuit, and I must accept this advice or risk losing my 6th Amendment right to effective representation. Accordingly, I assert my constitutional rights as guaranteed by the 5th, 6th, and 14th Amendment to the Constitution.
He knows exactly how to play this one. He's been through. He's not going to answer anything. And I'm just going to speed it up because it is tedious, I'll be honest. See how this goes.
And just for the record, I can only spell it the way that it was spelled in your flight logs from your airplane. I don't know exactly how she spells her name, only how your pilot would spell her name.
Form
So,
speculation.
if I misspelled it, I'm sorry.
Form speculation, argumentative, harassing.
That's
And
harassing.
assumes facts currently not in evidence in this particular deposition, and therefore move to strike.
I was responding to his question asking me how to spell her name. I don't know how, other than his own pilot.
Mr. Edwards, he asked you to spell the name. You then spelled the name, and then you went on another narrative. There wasn't a question posed on the floor.
You would agree that you interacted with every day in a sexual way when she was 15 years old, right?
Again, sir?
Sure, you would agree that you interacted with sexually on an everyday basis when she was 15 years old.
You know, again, Mr. Edwards, I'd like to answer all your questions here today. My attorneys have advised me that I must assert my 6th Amendment, 14th Amendment, and 5th Amendment rights provided by the U.S. Constitution. And the fact that the current U.S. Attorney has described your law firm as a criminal enterprise is one of the largest frauds in Florida's history for fabricating sexual cases of a sexual nature against me and others. Unfortunately, though I'd like to answer those questions, if I do, I risk losing my attorney's counsel. Therefore, I must assert my right.
All right, Madam Court Reporter, I'm going to attach as an exhibit the Jane Doe number 102 versus Jeffrey Epstein complaint at some point in time. It doesn't have to be done now, but it's going to be Exhibit 1 as I'm going to go through some of the facts as alleged in the complaint and as will be testified by the plaintiff.
Counsel, do you have an extra copy of that for me?
No.
May I look at it real quick?
No. Would you agree that you, and it has my notes on it.
No, I understood. I saw it.
But the notes are in highlighters, so when we copy it, it's not going to show up and you can have a copy.
Understood. That's fine. Just for the record, that is a current operative pleading, correct?
Correct.
What does that mean?
It means that there may have been some amendments to a complaint. I want to make sure that that is the operative complaint at issue that he's speaking from today.
Is it true that...
Can I go with the record, second? What? Can I ask you a question?
Sure. Can we take a break for a second?
Again?
Just if you want to speak with me for a second.
Going off the video record at 12:01 p.m. We're back in the video record at 12:02 p.m.
Is it true, Mr. Epstein, that you and Ghislaine Maxwell forced to have sex with you on a daily basis?
Form argumentative, harassing.
Unfortunately, at this time, though I'd really like to answer the questions, like I've done for most of your questions here today, Mr. Edwards, your firm was described as a criminal enterprise, a serious criminal enterprise by the current U.S. Attorney. Part of that criminal enterprise was fabricating cases of a sexual nature against me and others in order to fleece unsuspecting investors out of millions of dollars. So though unfortunately at this time, no matter how I'd like to respond to your questions, I must assert my 6th Amendment, 5th Amendment, and 14th Amendment rights under the U.S. Constitution or risk having my attorneys resign.
Isn't it true that was yours and Ghislaine Maxwell's sex slave from the time she was 15 through the time she escaped when she was 19.
Again, objection, argumentative, harassing.
Mr. Edwards, your firm has been described as as a criminal enterprise by the current U.S. attorney and part of the largest fraud in Florida's history.
That's 4 years. 4 years she couldn't escape for. You know, listen to how this is described. She escaped.
Part of that fraud is fabricating multiple cases against people like me and others of a sexual nature in order to fleece unsuspecting investors out of millions and millions of dollars. So though I'd like to answer that question, my attorneys have told me today I must assert my 6th Amendment, 14th Amendment, and 5th Amendment right.
Isn't it true that you and Ghislaine Maxwell celebrated her 16th birthday with her and had sex with her on that day?
Form, compound, confusing, argumentative, and harassing.
Mr. Edwards, I'd like to answer that question. My attorneys told me today that I have to, at least today, assert my 5th Amendment, 6th Amendment, and 14th Amendment rights to the U.S. Constitution. Especially, my concern is that your firm has filed fraudulent lawsuits, fabricated lawsuits, and the U.S. attorney, the current U.S. attorney, has described your firm as a criminal enterprise whose main purpose was to generate money for the firm and its co-conspirators through the operation of various criminal activities, including mail fraud, wire fraud, and money laundering.
Are you saying that the complaint of against you, the allegations in that complaint, are false?
Form, misinterprets the witness's testimony.
Or are you saying it's true?
Same objection.
It's either true or false.
What I said, maybe I'll repeat myself, unfortunately. But the current U.S. attorney has described your law firm was involved in the filing of motions. I'm sorry. Do you want to tell me what it was? What would you like to tell me the firm's involvement in this lawsuit? So since this will be here the rest of the day?
Answer the question.
Oh, that's fine. The U.S. attorney has described that firm as a criminal enterprise, perpetrating one of the largest frauds in Florida's history against unsuspecting investors, fleecing them out of millions of dollars by creating, crafting, and fabricating fallacious sexual claims against people like me and others. So unfortunately, though I'd like to answer your questions, Mr. Edwards, my counsel has advised me that at least today, I must assert my 6th Amendment, 5th Amendment, and 14th Amendment rights under the U.S. Constitution.
Isn't it true, sir, and I'm reading from the complaint filed by against you, isn't it true, sir, that a friend of yours sent you 3 12-year-old females for you to sexually abuse on one of your birthdays?
Form, argumentative, harassing, and irrelevant to this lawsuit.
But is you saying it's part of the lawsuit?
Yeah, I'll read it directly. On one of defendant Epstein's birthdays, a friend of defendant Epstein sent him 3 12-year-old girls from France who spoke no English for defendant to sexually exploit and abuse. After doing so, they were sent back to France the next day. Isn't that true?
Once again, I'm going to move to strike. Irrelevant, argumentative, harassing, and for the record, the exhibit that's being read from is a complaint that is unrelated to the incident matter and not filed or incorporated by the current plaintiff in this matter.
I would like to answer that question. I really would. However, today, my attorneys have told me I have to assert my 5th Amendment, 6th Amendment, and 14th Amendment rights under the U.S. Constitution, especially because your firm involved in this lawsuit has fabricated, widely reported, multiple cases of sexual harassment cases against individuals like me and others, perpetrating what the U.S. attorney called one of the largest frauds in Florida's history, fleecing people out of millions of dollars. So though I'd like to answer that question, today I have to assert those rights or risk losing my attorney's counsel.
Is it true that you forced as a 15-year-old girl to have sex with numerous friends of yours?
Are you kidding?
Reading from a lawsuit.
Oh, you're reading from a lawsuit. Oh, sorry, Mr. Evans. I'm going to have to, though I'd like to answer that question as well, as I answered most of your other questions here today, I would like to respond. My attorneys, however, have advised me I have to assert my 5th Amendment, 6th Amendment, and 14th Amendment rights under the U.S. Constitution, especially as your firm has been accused by the U.S. attorney as being a criminal enterprise and part of the largest fraud in Florida's history. Basically, I'm sorry if I read correctly, the operation of the enterprise through various criminal activities, including mail fraud, wire fraud, and money laundering, fabricating sexual harassment cases against people like me and others.
By the way,
Yes.
didn't receive a round-trip ticket paid for by you to and she ultimately did not get back on the plane, but instead escaped to
I'd like to answer that question. But today, I'm going to have to assert my 6th Amendment, rights, my Fifth Amendment rights, and my 14th Amendment rights under the U.S. Constitution, especially since your firm has been described as perpetrating one of the largest frauds in Florida's history, fleecing investors out of millions of dollars, being described by the U.S. Attorney of South Florida as a criminal enterprise, engaged in various criminal activities, including mail fraud, wire fraud, and money laundering.
You know a man named Jean-Luc Brunel?
Can you spell it?
He was at your house last week. Does that remind you?
Form, move to strike, speculation, argumentative, harassing. Is there a question on the table, Mr.
Yes, do you know him?
Could you spell his name for me, please?
I don't need to spell his name. You know who I'm talking about, Mr. Brunel.
I'm sorry, could you... Mr. what?
B-R-U-N-E-L.
I see. I would like to answer that question as well, but my attorneys have counseled me to that today. I'm going to have to assert my Sixth Amendment rights, my Fifth Amendment rights, and my 14th Amendment rights under the U.S. Constitution, or risk losing my right to effective representation.
What's the purpose for you asking me to spell his name? Are you acting like you don't know him?
Form, move to strike, argumentative, and irrelevant as worded. Mr. Edwards, you know that there are various standing orders, if not in this case, in various other cases, that specifically describe the protections of the Fifth Amendment. Federal courts have ordered that certain questions that you are asking shall not be answered, or Mr. Epstein would risk losing his Fifth Amendment right.
No, I understand that.
Under the United
States. Spell
States.
people's names.
Wait a second. Under the United States Constitution. A lot of these questions here today that you're asking have already been ruled on by various courts that the Fifth Amendment protects any response thereto. So I would like it. I'm giving you some leeway here with regard to these argumentative questions. We've already, and I'm not obviously testifying for the witness, but we've already handled a lot of these issues in court, and we've already adjourned one deposition for being argumentative, and I think you understand what the court said there. So, having said that, and I understand that you have a job to do, but having said that, I would like to caution you professionally that if you continue with the argumentative questions, I am going to have to terminate this deposition, and then we'll just...
Do what you have to do, Mr. Pike. I completely understand.
Okay. We're here today...
Mr. Brunel is
I'm sorry, just go ahead. We're here, I want the court to know that we're here today to allow you to ask your questions, but the harassing and argumentative tone is not going to be tolerated. So
there's a video. There's a video. We can show the court the tone. It's obviously not harassing. So, Mr. Brunel is a longtime friend of yours, right?
I intend to respond to all relevant questions to this lawsuit. However, today, my attorneys have counseled me that I cannot provide answers to any questions that may be relevant to this lawsuit, and I must accept their advice or risk losing my Sixth Amendment right to effective representation.
You know him as somebody who has been caught engaging in sex with underage minors in the past. Is that correct?
You'll have to repeat the question, sorry.
You know Mr. Brunel as somebody who has been caught engaging in sex with minors in the past. Is that correct?
Sure. I intend to respond to all relevant questions regarding this lawsuit. However, at the present time, my attorneys have counseled me that I cannot provide answers to any questions relevant to this lawsuit, and I must accept their advice or risk losing my Sixth Amendment right to effective representation. As your firm has been described by the U.S. Attorney as a criminal enterprise and part of one of the largest frauds in Florida's history, it specifically said you've been fabricating, the law firm was fabricating multiple cases involving a sexual nature in order to fleece unsuspecting investors out of millions of dollars, including mail fraud, wire fraud, and money laundering. So unfortunately, though I'd like to answer all your questions here today, I must assert my Sixth Amendment, 14th Amendment, and Fifth Amendment right.
And you were involved in a modeling business with him called MC Squared. Is that correct?
Again?
You were involved in a modeling agency
What do you
with
mean by
Mr. Brunel.
I'm sorry about that. He's talking about the modeling agency MC Squared that's still running today. And it was an investment made through Epstein. And yes, as I say, it's still running. These trafficking situations are still ongoing. There's still more to come, in different areas of the world,
Sorry.
called MC Squared.
Involved means what? Sorry. What do you mean?
Well, you tell the jury your involvement with the modeling agency. You can clarify. I'll let you do that.
No. I intend to respond to all relevant questions regarding this lawsuit. However, at the present time, my attorneys have counseled me that I cannot provide answers to any questions relevant to this lawsuit, and I must accept their advice or risk losing my 5th, 6th, and 14th Amendment rights under the U.S. Constitution.
And when you were being criminally investigated and was in, is it true that you made a personal telephone call to her telling her not to come forward with any of the information she knew?
Form.
Again, sorry, this
When you were being, I'm putting a time frame on it, the time period where you were being criminally investigated.
What time frame is that?
In her complaint, it's not specific. But at some point, let's just make it whenever. At some point in time, did you place a telephone call to in Australia, warning her not to come forward with any information about you engaging in sex with her while she was a minor?
Form.
I intend to respond to all relevant questions regarding this lawsuit. However, at the present time, my attorneys have counseled me that I cannot provide answers to any questions relevant to this lawsuit, and I must accept their advice or risk losing my 6th Amendment right to effective representation.
With respect to underage females, isn't it true that you have made the statement, in quotes, the younger the better?
Form.
Again, as your firm has been described by the current U.S. Attorney as a criminal enterprise involved in mail fraud, wire fraud, money laundering, and specifically crafting, fabricating multiple cases of a sexual nature against people like me and others in order to fleece many, many unsuspecting investors out of millions of dollars, I would like to answer your questions here today, Mr. Edwards. But unfortunately, my attorneys have counseled me that I must assert my 5th, 6th, and 14th Amendment right, or they will resign.
Who are your current employees?
Form.
Again?
Who are your current employees? People who work for you that you pay.
I intend to respond to all relevant questions regarding this lawsuit. However, at the present time, my attorneys have counseled me that I cannot provide answers to any questions that may be relevant to this lawsuit or risk losing my 6th Amendment right to effective representation. Accordingly, therefore, I must assert my 5th Amendment, 6th Amendment, and 14th Amendment rights as provided by the U.S. Constitution.
Isn't it true that you pay your employees to bring you underage minor females for sex?
Form. Argumentative speculation. Harassment.
Mr. Edwards, your firm has been described by the current U.S. Attorney as a criminal enterprise. A criminal enterprise. Part of the largest fraud in South Florida's history. Part of that fraud was fabricating fictitious cases against people like me of a sexual nature in order to fleece unsuspecting investors out of millions of dollars. Unfortunately, at this time, though I'd like to answer every one of your questions, my attorneys advised me that I must assert my 6th Amendment, 14th Amendment, and 5th Amendment rights or risk losing them as my attorneys.
Isn't it true when underage females were brought to you, you would engage in sex with them and pay them?
Form. Argumentative. Harassing.
Are you shaking your head to say no?
Excuse me?
Are you shaking your head to say no? I don't know how to interpret the answer.
I'm sorry, I didn't realize I was shaking my head.
Okay.
One second.
I thought he was actually answering a question.
Move to strike. The rules are well known to every lawyer who practices in the state of Florida that it's clear that a nod of the head or a shake of the head is not understood by the record. So therefore, Mr. Epstein clearly was not responding to one of your questions, and you know that, Mr. Edwards.
This is on video, Mike.
Nonetheless, you know the rules. Nonetheless, if we have a question on the table, would you please repeat it so I can recall it And so Mr. Epstein can endeavor to answer it.
Sure, and if it was only a court reporter, I would agree, but the jury's going to see a video, and everybody knows commonly, if somebody shakes their head, they're saying no. If that was the answer, I wanted to give them a chance to elaborate on it. That's it. Isn't it true that when underage females would come to your house, you would engage in sexual activity with them and then pay them?
Same projections.
Unfortunately, I'd like to answer that question today, but my attorneys have counseled me that I must assert my Sixth Amendment right, my Fifth Amendment right, and my 14th Amendment right under the U.S. Constitution. The fact that your firm has been described as a criminal enterprise and part of one of the largest frauds in South Florida's history, part of that fraud has been described as fabricating cases of a sexual nature against me and others in order to fleece unsuspecting investors out of millions of dollars. I would like to answer that question, Mr. Edwards. But however, today, I must assert my 5th, 6th, and 14th Amendment right.
In addition to paying these underage females for sexual activity, you also paid them to bring their underage friends to you to also engage in sexual activity with. Is that correct?
I intend to respond to all relevant questions regarding this lawsuit. However, at the present time, my attorneys have counseled me that I may not. And they have advised me I must assert my 6th Amendment right, my 5th Amendment right, and my 14th Amendment rights under the U.S. Constitution.
You would pay underage females $200 to $300 for engaging in sexual activity with you, or for procuring another underage female to engage in sexual activity with. Is that correct?
Form, move to strike, assumes facts not in evidence, and calls for a legal conclusion, and is as well argumentative.
I intend to respond to all relevant questions regarding this lawsuit. However, at the present time, my attorneys have counseled me that I cannot provide answers to any questions that may be relevant to this lawsuit, and I must accept their advice or risk losing my 6th Amendment right to effective representation. Accordingly, therefore, I must assert my constitutional rights as guaranteed by the 5th, 6th, and 14th Amendment to the U.S. Constitution.
Would you agree that your scheme was devised to coerce these underage minors to bring you as many other underage minors as were available for you to engage in sexual activity with?
Form.
Can you repeat the question?
Yeah. Would you agree that your scheme was devised to coerce underage girls into bringing as many other underage girls to you as were available for sexual purposes?
Form.
Did you say for sexual purposes?
Yes, for sexual purposes.
I'm not surprised. I'm sorry. Since your firm was described as perpetrating one of the largest frauds in Florida's history by crafting fabricated sexual harassment cases against people like me and others in order to fleece unsuspecting investors out of millions of dollars, I would like to answer that question. However, today, my attorneys have advised me I must assert my 6th Amendment, 5th Amendment, and 14th Amendment right under the U.S. Constitution. And if I don't do so, I risk losing effective representation.
Utilizing this method of using underage minors to bring you other underage minors, you were able to engage in sex with hundreds of underage minor females. Is that true?
Form, argumentative, harassing, calls for speculation.
Since, Mr. Edwards, your firm has been described as a criminal enterprise by the U.S. Attorney, and as part of the largest fraud in South Florida's history, and as part of the fraud fabricating malicious cases of sexual harassment and other cases of sexual nature against people like me and others, though I'd like to answer that question today, my attorneys have advised me I must assert my 6th Amendment, 14th Amendment, and 5th Amendment rights of the U.S. Constitution. Though I believe you know I'd really like to answer your questions, but at this moment, if I don't assert those rights, I risk having my attorneys resign.
Isn't it true that with this method, you were able to interact sexually with underage girls every single day?
Form, ask and answer.
Go ahead.
I'm sorry. Can you repeat it?
Sure. With this method of
This
using
method being what? Sorry?
your method of using underage minors to bring you other underage minors for sex, isn't it true that that method resulted in you engaging in sexual activity with underage minors on an everyday basis?
Same objections.
Your firm has been described by the current U.S. Attorney as a criminal enterprise engaged in one of the largest frauds in South Florida's history, and as part of that fraud, creating, fabricating malicious cases of sexual nature against people like me and others. So unfortunately, though I'd like to answer that question today, I must assert my 6th Amendment, 14th Amendment, and 5th Amendment rights that my counsels advised me to do. Though I believe you know I'd really like to answer those questions today, I must assert those rights or risk losing my attorney's representation.
To keep track of all of these underage minors, you stored their names and telephone numbers in your home computer, isn't that correct?
Form argumentative speculation.
Again? Sorry.
Are you going to answer the question or just read? If you are going to answer the question, of course, I'll keep reading it as many times.
Wait 1 second. The witness is attempting to answer your question. He asked you to repeat the question.
He is?
He asked you to repeat the question.
And I don't mind going through that, Mike, because I do want answers. But if I'm going to repeat the question multiple times and still get the same answer, we're just wasting time. I'm just trying to stop us from wasting time repeating questions if I'm getting the same non-responsive answer.
I understand your intention here.
Yeah.
However, these questions are similar in nature, if not identical, to various questions that you've asked in other cases. So you coming here today is of no surprise that Mr. Epstein is required to invoke his 5th, 6th, and 14th Amendment rights underneath the United States Constitution.
I understand that.
If you came here today thinking that you were going to pull a rabbit out of a hat and get, waive Mr. Epstein was going to waive his 5th, 6th, and 14th Amendment rights to the United States Constitution, at least not today. That will not be occurring.
Is it true that to keep track of the names and phone numbers of these underage minor females you interacted with sexually, you stored those names and phone numbers in your home computer?
Thank you. I've heard the question now. So it doesn't surprise, again, I've now heard your question, and the fact that your firm has been described as a criminal enterprise by the current U.S. attorney in South Florida, and part of one of the largest frauds in Florida's history. It is reported that your firm fabricated malicious cases of a sexual nature against people and against me in order to fleece unsuspecting investors out of millions of dollars. Unfortunately, though, I'd like to answer each one of your questions today, Mr. Edwards. My attorneys have advised me that I must assert my 6th Amendment, 5th Amendment, and 14th Amendment rights under the U.S. Constitution. So though I'd like to answer, I must assert those rights or risk having my attorneys, resign.
Do you know?
I intend to respond to all relevant questions regarding this lawsuit. However, at the present time, my attorneys have counseled me that I cannot provide answers to any questions relevant to this lawsuit, must accept their advice, or risk losing my 6th Amendment right to effective representation.
Is it true that you employed to contact underage minor females and make them appointments to be at your house?
Sorry, again.
Isn't it true that you employed for the purposes of contacting underage minor females and scheduling them appointments to be at your house?
The current U.S. attorney has described your law firm, Mr. Edwards, as a criminal enterprise engaged in one of the largest frauds in South Florida's history. It has been reported that your firm fabricated multiple cases of a sexual nature against me and others in order to fleece unsuspecting investors out of millions and millions of dollars. So though, unfortunately, I'd like to answer every one of your questions today. My attorneys have counseled me that today I must assert my 6th Amendment, 5th Amendment, and 14th Amendment rights under the U.S. Constitution. Though I believe you know I'd like to answer those questions, but today, at this moment, I must assert those rights or risk having my attorneys resign.
Tell the jury how you know.
Form. Move to strike.
Move to strike my question? On what basis?
Do I have to state a basis? Usually I'm just required to state form.
Done more than that.
If I went on a diatribe of explaining, what's confusing, compound, irrelevant, then you would blame me for testifying for the witness. So I just moved to strike the question.
Make sure we mark that somewhere on this transcript, somehow. Tell the jury how you know.
Move to strike.
I intend to respond to all relevant questions regarding this lawsuit. However, at the present time, my attorneys have counseled me that I cannot provide answers to any questions relevant to this lawsuit and must accept their advice or risk losing my 6th Amendment right to effective representation. Accordingly, I assert my 5th Amendment, 6th Amendment, and 14th Amendment right under the U.S. Constitution.
Isn't it true that you brought her to this country when she was underage and made her your sex slave, and you have bragged about this?
Form, argumentative, compound, harassing, and calls for speculation.
I intend to respond to all relevant questions regarding this lawsuit. However, at the present time, my attorneys have counseled me that I cannot provide answers to any questions relevant to this lawsuit, and I must accept this advice or risk losing my 6th Amendment right to effective representation. However, so I'm clear, the question was, did I bring her here? So we're clear. What was specifically what you did?
Your answer's fine.
Okay.
Is it true that you demanded numerous underage minor females to have sex with inside your home while you watched masturbating?
Same objections.
Okay.
You have to repeat the question so I'm clear.
Isn't it true that you have ordered several underage minor females to have sex with in your home while you watched masturbating?
Objections. The current U.S. attorney has described your firm, Mr. Edwards, as a criminal enterprise involved in mail fraud, wire fraud, money laundering, and in fact fabricating multiple cases of a sexual nature against me others in order to fleece unsuspecting investors in South Florida out of millions and millions of dollars. Unfortunately, though, I'd like to answer each one of your questions here today. My attorneys have advised me that I must assert my 6th Amendment, 14th Amendment, and 5th Amendment right under the U.S. Constitution. Though I believe you know that I'd like to answer your questions, but at this moment I must assert those rights or risk having my attorneys resign.
Is it true that with each of these underage minor females that was brought to your house, your method of sexually exploiting them was nearly identical? Is that correct?
Objection. Argumentative, confusing, overbroad, and vague.
I don't even understand the question.
Okay. Well, when a 14 or 15-year-old would be led into your bedroom, you would appear from the shower first, usually naked. Is that correct?
Objection. Argumentative, assumes facts not in evidence, and harassing.
I intend to respond to all relevant questions regarding this lawsuit. However, today, my attorneys have advised me that I cannot provide answers to any questions relevant to this lawsuit and must accept their advice or risk losing my 6th Amendment right to effective representation. Accordingly, therefore, I must assert my constitutional rights again as the 5th Amendment, 6th Amendment, and 14th Amendments to the U.S. Constitution.
Can we go off the record for a second?
If it's necessary.
Yeah, well, let's go off the record.
Want to take a break or something?
Video record at 12.
She needs an agreement from you to go off the record. I learned that.
We're back in the video record at 12:44 p.m.
Can you tell me what my last question is, or is that... It's okay. I can pick up. Or
I can tell you, too.
Okay.
This is my
All right.
Okay, when a 14 or 15-year-old would be led into your bedroom, you would appear from the shower first, usually naked. Is that correct? Have your objection, Mr. President.
Okay. Thank you. And after appearing from the shower naked, you would order the underage minor female to disrobe. Isn't that true?
Same objections.
I intend to respond to all relevant questions regarding this lawsuit. However, at the present time, my attorneys have counseled me that I cannot provide answers to any questions relevant to this lawsuit and must accept their advice or risk losing my 6th Amendment right to effective representation. Excuse me.
You would then order them order her to begin providing you a massage. Is that correct?
Excuse me. I intend to respond to all relevant questions regarding this lawsuit, and I'd like to answer each and every one of your questions today, Mr. Edwards. However, my attorneys have told me that I cannot do that today. I must assert my 6th Amendment, 5th Amendment, and 14th Amendment rights under the U.S. Constitution, or risk losing my counsel. Therefore, I'm going to assert those rights as guaranteed by the 5th Amendment, 6th Amendment, and 14th Amendment.
You would then roll over and begin masturbating. Is that correct?
I intend to respond to all relevant questions regarding this lawsuit. It's my understanding that the current U.S. Attorney has described your law firm as a criminal enterprise. Yours and Mr. Jaffe's firm is a criminal enterprise and part of the largest fraud in Florida's history. Excuse me. Fabricating malicious cases of a sexual nature against me and others in order to fleece investors out of millions of dollars through bogus schemes, including conspiracy to commit mail fraud, wire fraud, and money laundering. So though I'd like to answer each and every one of your questions here today, my attorneys have counseled me that I cannot and must assert my 5th, 6th, and 14th Amendment rights under the U.S. Constitution.
You would then rub the underage minor female's vagina or insert your fingers into her vagina. Is that correct?
I intend to respond to all relevant questions regarding this lawsuit. Unfortunately, today, my attorneys have advised me I cannot and must assert my rights under the U.S. Constitution under the 5th Amendment, 6th Amendment, and 14th Amendments of the U.S. Constitution, especially since your firm has been described as a criminal enterprise by the current U.S. Attorney, perpetrating one of the largest frauds in South Florida's history, fleecing investors out of millions of dollars by fabricating malicious cases of a sexual nature against people like me and others.
And with many of these underage minors, you would use vibrators on them. Is that correct?
I would like to respond to that question, as I'd like to respond to all your other questions today. However, my attorneys have counseled me, excuse me, that I must assert my 6th Amendment rights, my 5th Amendment rights, and my 14th Amendment rights under the U.S. Constitution.
And with many of these underage minors, you would give and or receive oral sex from them. Is that correct?
I intend to respond to all relevant questions regarding this lawsuit. I'd like to answer each and every one of your questions. However, my attorneys have counseled me that today I must assert my 6th Amendment, 5th Amendment, and 14th Amendment rights under the U.S. Constitution, especially since your firm has been described by the current U.S. Attorney as perpetrating one of the largest frauds in Florida's history by fabricating malicious cases of a sexual nature against me and others.
In June of 2008, you pled guilty to a couple felonies, right?
Vague and confusing.
Again,
In June of 2008, you pled guilty to 2 felonies. Is that correct?
Same objection.
Yes.
And what were those felonies that you pled guilty to?
solicitation of prostitutes, not underage prostitutes, but simply prostitutes, solicitation of prostitutes, and 1 count of procuring a minor for underage sex.
And you have taken the fifth as to questions related to many of these underage minors, but the underage minors that were the victims in the cases where you pled guilty were, was that one of them?
Form mischaracterizes the witness's testimony, causes for a legal conclusion.
Again?
What was the name of any of the underage minors that were the subject of the criminal charges to which you pled guilty?
I don't know.
So tell me about those charges. What was the allegations of those charges?
Form.
Solicitation of prostitution.
Okay.
Not underage prostitution, prostitution.
Were the victims, or the prostitutes, as you would say, were they minors?
Form.
I pled guilty to solicitation of prostitution.
Okay, so tell me what those cases were about. What happened?
I have no more. I can't tell you any more than that.
You don't know what you pled guilty to?
I just told you.
Objection form, that's asked and answered.
Do you know what you pled guilty to? The facts.
Solicitation of prostitution.
I understand that's the charge. What were the underlying facts?
Sorry?
What'd you do? Did you pull up in a car, talk to the person? Did they come over to your house? How'd you get them? Those kind of things. Tell the jury what were the underlying facts about the charge that you pled guilty to?
Form, move to strike.
I don't know.
You don't know what you pled guilty to.
I pled guilty to solicitation of prostitution. Not underage prostitution, but prostitution.
Okay. My understanding from reading the court file is that one of those females was. Do you know who that is?
I intend to respond to all relevant questions to this lawsuit. However, at the present time, my attorneys have counseled me that I cannot provide answers to any of these questions today. So accordingly, I must assert my constitutional rights under the 5th, 6th, and 14th Amendments of the U.S. Constitution.
You're aware that is somebody that alleges she was at your house on more than 100 occasions. Is that true?
Form.
Can you repeat the question, sorry?
Are you aware that is a female that alleges that when she was underage, she was at your house on more than 100 occasions?
Form. Predicate.
I intend to respond to all relevant questions to this lawsuit, Mr. Edwards. However, today, my attorneys have counseled me that I must respond by invoking my 5th Amendment right, my 6th Amendment right, and my 14th Amendment rights under the U.S. Constitution, so, unless or risk losing them as my attorneys. Excuse me. So therefore, I must assert those rights.
And you understand that her complaint was that Epstein turned onto her stomach on the massage bed and inserted his penis into her vagina. Stated Epstein began to pump his penis in her vagina, and she became upset over this. She said her head was being held against the bed forcibly as he continued to pump inside her while she screamed no. Are you aware of those allegations?
Form. Predicate.
I'm sorry, did you say there was a complaint?
In the incident report that led to a charging document that led to a charge that you have pled guilty to. Are you aware of that information coming from?
I'm sorry, Mr. Edwards. What are you reading from?
The 87-page Palm Beach Police Department incident report where there are numerous underage females describing their interaction with Mr. Epstein at his house. I'm reading specifically from page 41 related to who was one of the victims pled guilty to.
Is that the same document that you're seeking production of in this same exact case?
I don't know what you're talking about. This is something from the state attorney's file.
Okay. Sorry, what's the question?
Are you aware of that allegation? What I just read to you.
I'd like to answer that question. But however, today my attorneys have advised me I must assert my 5th Amendment, 6th Amendment, and 14th Amendment rights under the U.S. Constitution.
Some of your attorneys have advised you that because of res judicata, double jeopardy, you cannot be charged for any crimes that you have already pled guilty to related to. So I'd like you to just explain to the jury, in your words, or your version of the story, what was your interaction with at your house when she was a minor?
Object to form, as worded, could disclose attorney-client communications.
I intend to respond to all relevant questions regarding this lawsuit. I'd like to answer each one of your questions today. However, my attorneys have counseled me that I may not. They've advised me that I must assert my 5th Amendment, 6th Amendment, and 14th Amendment rights under the U.S. Constitution. Therefore, if I don't, I risk losing their counsel. So therefore, I must assert those rights here today, Mr. Edwards.
Are you aware that advised police that she was ripped and torn in her vagina area and had difficulty walking to the car after this episode where you forcibly inserted your penis into her vagina?
Objection. Relevance. Argumentative. Compound. Harassment.
The question was, are you aware?
The current U.S. attorney, since he's described your firm as a criminal enterprise, and part of one of the largest frauds in Florida's history, by fabricating malicious cases of a sexual nature against people like me and others, and fleecing investors out of millions of dollars by using means described in the complaint against your firm. It's including mail fraud, wire fraud, money laundering. I'm afraid today, though I'd like to answer each one of your questions, my attorneys have counseled me that I must assert my 6th Amendment, 5th Amendment, and 14th Amendment rights under the U.S. Constitution. And though I believe you know I'd like to answer those questions, I must assert those rights at risk losing my attorney's representation.
Do you know?
Spell it for me, please.
I don't know how to spell her name, but do you know? I don't know that she ever would have spelled her name for you.
Form, name to strike.
I intend to respond to all relevant questions regarding this lawsuit. However, at the present time, my attorneys have counseled me that I may not provide answers today, though I'd like to. And I must, in fact, take their advice or risk losing their representation. So therefore, I must assert those rights under the U.S. Constitution.
Do you know the names of any of the females that you allegedly solicited for prostitution and pled guilty to?
Relevance.
Sitting here today, no, I do not.
You asked me to spell his name. That's somebody that your attorneys took her deposition about a year and a half ago. Does that help to refresh your recollection?
I'd like to answer that question, but today, according to my attorneys, I must assert my 5th Amendment, 6th Amendment, and 14th Amendment rights under the U.S. Constitution. I must accept their advice or risk losing my 6th Amendment right to effective representation, Mr. Edwards. So though I'd like to answer the question, today I must assert those rights.
There's another victim. Her name is that was listed as one of the females at your house that you pled guilty to the solicitation of. And I'd like to ask you if you remember her.
Form, confusing, compound.
I don't know her first name. It's initials, last name.
Same objection.
I intend to respond to all relevant questions regarding this lawsuit. However, at the present time, my attorneys have counseled me that I cannot provide answers to any questions relevant to this lawsuit, and I must accept their advice or risk losing my right to effective representation. Therefore, though I'd like to answer the questions, I must assert those rights today.
With each case that results in a charge as and
Is this in order? Sorry. I'm sorry.
we're stopping again.
No, this one can get some water. You don't have to stop. Just, Mr. Jaffe, could you pass some water?
Is there water? No water.
Oh, sorry. I'll go.
With each conviction charge, or with each charge that leads to a conviction, there are facts and circumstances that lead up to that plea of guilty. What are the facts and circumstances that led to you pleading guilty to the two felonies that you described?
Form, overbroad, compound, confusing, calls for a legal conclusion.
I'd like to respond to that question. But today, my attorneys have advised me I must assert my 5th Amendment, 6th Amendment, and 14th Amendment rights to the U.S. Constitution, or risk losing effective representation. Accordingly, I must assert my constitutional rights as guaranteed by the Constitution.
Just so we're clear, because your attorney made an objection that it was unclear, and then you invoked your 5th Amendment rights.
I'm sorry.
I'm talking about the cases where you've already pled guilty. You can't be charged again. What were the facts and circumstances that led up to you pleading guilty to these felonies?
I've answered the question, I think, but
Same objection. Ask and answer.
Okay. And just so the jury understands, these three females that were the subject of the guilty pleas in state court were procured by your method of having underage minor females locate other underage minor females and bring them to your house. Is that correct?
Objection. Argumentative, compound, harassing, assumes facts not in evidence.
You'll have to
And I move to strike.
I have to repeat the question.
Okay. Are all people that were, at the time you engaged in sexual activity with them, were underage and were brought by other underage minor females? Is that true?
Same objections incorporated, as well as the motion to strike.
I don't understand. I'm sorry, I don't even understand the question.
Isn't it true that you used underage minor females to bring other underage minor females to your house for sex?
Ask and answer. Way earlier on.
Well, he doesn't understand the question, so I'm
You can
going
answer
through
if you
the
understand.
Not a problem.
But it is ask and answer.
As your firm, Mr. Edwards and Mr. Jaffe, has been described by the U.S. Attorney as perpetrating one of the largest frauds in South Florida's history by crafting malicious cases of a sexual nature against people like me and others in order to fleece, using bogus schemes, in the U.S. Attorney's words, investment schemes. Unfortunately, though, I'd like to answer every one of your questions if I'm able. My attorneys have advised me I must assert my 6th Amendment, 14th Amendment, and 5th Amendment rights under the U.S. Constitution. Therefore, at the moment, I cannot answer that question.
The acts related to your guilty plea occurred at your Palm Beach house. Is that correct?
Form.
Again, sorry.
Well, if you were soliciting prostitutes, it wasn't out on the street, it wasn't in a hotel. These were girls that you solicited to be prostitutes at your house in Palm Beach, correct?
Objection. Relevance. Argumentative. Calls for speculation as worded and assumes facts not in evidence.
Though I'd like to answer that question, My attorneys today have advised me I cannot answer it today. They've advised me I must assert my 6th Amendment, 5th Amendment, and 14th Amendment rights under the U.S. Constitution. Otherwise, I risk losing their representation. So accordingly, I must assert those rights, Mr. Edwards, Mr. Jaffe.
In what county did you plead guilty to these felony offenses?
Palm Beach County.
So these were crimes that occurred here in Palm Beach County.
Form.
Is that correct?
I pled guilty in Palm Beach County.
Isn't it true that you kept a calendar or schedule? Okay, check.
Turn off the video record at 1:05 p.m. We're back on the video record at 1:15 p.m.
Epstein, as it relates to the charges you pled guilty to, are you saying today that those females that you interacted with sexually were prostitutes prior to meeting you?
I'm saying I pled guilty to the solicitation of prostitution.
Right, and you would certainly agree that that would require yourself and one other individual for that act of prostitution, correct?
Form. Also calls for a legal conclusion. I pled guilty to solicitation of prostitution.
And are you saying that those females that were the victims, at least listed as victims by the state, were prostitutes prior to meeting you?
Form. Vague. Irrelevant. I pled guilty to solicitation of prostitution.
Okay. Do you have any remorse for your action against these victims that led to your plea of guilty?
Form. Argumentative. I pled guilty to solicitation of prostitution. Not underage prostitution, simply prostitution.
Are you saying now that the subjects of that, which we're calling victims, were not underage when you engaged in sex with them?
Form. Argumentative. Speculation. And assumes facts not in evidence as well as mischaracterizes the witness's testimony.
I pled guilty to solicitation of prostitution. Not underage prostitution, solicitation of prostitution.
I was of the impression that you pled guilty to a second-degree felony, that being procuring a minor for the purposes of prostitution.
That's correct.
Okay, so a minor is somebody under the age of 18, and I'm asking for the guilty plea related to that count. Are you at all remorseful for your interactions with that minor?
Same objections.
What minor?
The charge is procuring a minor. You tell me, who was that minor?
I don't know.
You were never told during your during the state attorney's prosecution of you who this person was?
No.
Why did you plead guilty to a felony charge that resulted in you going to jail, without even knowing who the victim was?
Form. That question calls for attorney-client information, and therefore I'm instructing.
If it has something to do with any conversations with your attorney, I don't want to know. I'm just going off of the plea colloquy between you and the judge, where you understood the charges and you've been advised and apprised of the charges, and you still willfully pled guilty to the charges. So I'm taking now that you're saying you don't even know what those charges were about.
What was the question? And I don't know the question on the table.
Who was the minor?
I don't know.
And you were never told the name or initials of that minor victim by the state attorney's office or the prosecutor?
Not that I recall.
Just so that the jury understands, this method of paying underage minor females to bring you other underage minor females for sex is something that you do in New York, in New Mexico, in Florida, and everywhere. It's not just West Palm Beach, isn't that right?
Again, form. It's compound. Again, it assumes facts not in evidence. It's argumentative. It's harassing. And moreover, we've already been down this road before in separate related questions that have already been asked and answered.
I'd like to respond to each one of your questions. However, today, my attorneys advise me I cannot. And they advise me I must assert my 6th Amendment right, my 5th Amendment right, my 14th Amendment right under the U.S. Constitution. Therefore, that's what I'm going to do.
Where is the calendar or schedule of your underage sex appointments?
Form. Speculation.
Okay. Sorry, you said what?
Witness said again.
Where is the calendar or schedule that's kept for you of your underage sex appointments? Your appointments for sex with underage females?
Same objection.
And if there's not one, you can tell me there's not one.
So I'd like to answer each one of your questions today. However, I've been advised by counsel that I must assert my 5th Amendment, 6th Amendment, and 14th Amendment rights under the U.S. Constitution, or risk losing their representation. Therefore, I'm going to have to assert those constitutional rights, though I'd like to answer that question.
Are you still in possession of the computers that were taken from your house prior to the execution of the search warrant?
Again, am I still?
Are you still in possession of the computers that were removed from your house just prior to the execution of the search warrant?
I intend to respond to all relevant questions regarding this lawsuit. However, at the present time, my attorneys have counseled me that I cannot provide answers to any questions, Joe, that may be relevant to this lawsuit, no matter how much I'd like to. So I must accept this advice or risk losing my Sixth Amendment right to effective representation. Therefore, I must assert my rights under the Fifth, Sixth, and 14th Amendment of the U.S. Constitution.
Who was it that removed those computers from your house prior to the execution of the search warrant?
Predicate. I intend to respond to all relevant questions regarding this lawsuit. However, at the present time, my attorneys have counseled me that I cannot provide answers to any questions that may be relevant to this lawsuit, no matter how much I'd like to. And I must accept their advice or risk losing their representation. Accordingly, therefore, I'd have to assert those rights.
It's my understanding that this computer system contained the complete list of names of underage minor females with whom you engaged in sexual activity. Is that correct?
You're asking me is your understanding?
No.
You're asking for me to tell you what your understanding is?
Did the computers that were removed from your home just prior to the execution of the search warrant contain the complete list of underage minor females with whom you engaged in sexual activity?
Though I'd like to answer that question, like all your other questions here today, unfortunately, my attorneys have counseled me that I'm going to have to assert my Sixth Amendment, Fifth Amendment, and 14th Amendment rights under the U.S. Constitution. I point out that your firm was described by the current U.S. Attorney as a criminal enterprise involved in money laundering, creating and fabricating malicious cases of a sexual nature against people like me and others in order to fleece local investors out of millions of dollars. I believe the senior partner of that firm currently sits in jail. Unfortunately, though, I'd like to answer all your questions. Today, my attorneys have counseled me I must assert my rights under the Sixth Amendment, 14th Amendment, and 5th Amendment of the U.S. Constitution.
Isn't it true that you operated as an organized criminal enterprise designed to sexually exploit minors?
Objection. Argumentative. Speculation. Calls for a legal conclusion and continues to assume facts, not evidence.
Though I'd like to answer that question, Mr. Edwards, like most of your other questions here today, and hopefully we'll get to do so at some point, my lawyers have advised me that I must today assert my constitutional rights under the Sixth Amendment, Fifth Amendment, and 14th Amendment of the U.S. Constitution. And I must accept their advice or risk losing effective representation.
And as part of that organization, you developed code terms such as work or massage as opposed to engage in sex with minors. Is that true?
Form, argumentative, speculation, harassing, assumes facts, not evidence.
You developed code terms such as you would ask these girls if they would like to give you a massage or work for you, rather than asking them to do what was going to be done, which is engage in sexual activity with you. Is that true?
Same objection. Objections.
Are you asking if I developed code words? Is that the question?
Code words.
I'd like to respond to that question. Unfortunately, today my attorneys have told me I have to respond by invoking my Sixth Amendment, 14th Amendment, and 5th Amendment rights under the U.S. Constitution, or risk losing my amendment right to effective representation. Accordingly, I assert my constitutional rights as guaranteed by those amendments.
But what did it mean within your organization when someone, some underage minor female, was coming over to work for you?
What did it mean?
Right, what did it mean? What did it mean to you was going to happen when an underage minor female would either call to work or would tell you this person is coming to work for you at a specific time?
An objection. Vague, speculative, and assumes facts, not evidence.
I'd like to answer that question, as most of your other questions today. However, today my attorneys have counseled me that I must invoke my Sixth Amendment, 14th Amendment, and 5th Amendment right. And if I don't, I risk losing them as my attorneys, so therefore I must assert those rights.
You're laughing as if my questions are ludicrous right now, but you're aware that there were trash pulls from your home where there were message pads, messages taken by various employees of yours, where these terms, massage, work, were used in conjunction with underage minor females coming over to your house, aren't you?
Same objections form as well, but it's a strike. And also assumes facts, not evidence. It lacks predicate.
You're aware of the trash pull and the message pads, correct?
Same objections. Do you have any documents with you here today that you speak of?
No, but at this point in time of the trial, they'll already be in evidence, so.
I'm aware of the trash pull. What's the trash pull? I'm sorry.
Are you aware of... I'll ask it to you this way. When would take a phone message for you, what would she write it down on?
Form. The question makes no sense to me, sorry.
If another employee of yours were to answer the telephone, be it your housekeeper, house manager, would answer the phone, take a message for you, and write it down so that you could read it later, what would that message be written on?
Most likely paper.
Okay, and is that paper typically in the form of a message pad that has a carbon copy sheet to the back?
No.
Now, you're unfamiliar with the documents that I'm talking about, that being a message pad that informs you as to who called, the time they called, and the purpose for calling.
And for purposes of the question, we're specifically talking about a message pad, nothing related to what you're defining as a trash report, just what someone takes as a message.
Do I know what a message pad is?
No. Do you, in your home, do you typically have your housekeeper, house manager, or somebody else, and they take a message for you, write on a specific pad that informs you as to who's calling, the time they're calling, and the purpose for them calling, and there's a carbon copy sheet evidencing that message?
Objection, asked and answered.
Do you know what I'm talking about? I mean,
I know what a message pad is.
do you know what the message? Do you use them commonly in your home, or did you back prior to your arrest?
I'd like to answer that question, but today my attorneys have advised me I have to assert my Fifth Amendment, Sixth Amendment, and 14th Amendment rights under the U.S. Constitution. So therefore, I'm going to do that when I risk losing their representation.
Is my question to you confusing? I mean, do you know what I'm talking about?
Sure. Not specifically, no.
Okay. The information.
Is it something you have to show me so I know what you're talking about?
I don't have it to show you today, but if the information and evidence that I have learned through this process is accurate and correct, it would seem a foregone conclusion that you and I would be on the same page at least about this document. So,
okay,
if we're going to get to a point where you're going to tell me, hey, this document doesn't exist, or I don't know what you're talking about at all, okay, that's fine. But that's something that we can. So here's my question: when a housekeeper or house manager would take a message for you from any caller, is there a specific message pad that has a carbon copy located near your telephones for them to write down the name of the caller, the purpose for the call, and the time called? 4. Is that something you're familiar with?
I'd like to respond to that question. Today my attorneys have counseled me that I must assert my Sixth Amendment, Fifth Amendment, and 14th Amendment right under the U.S. Constitution.
So you're invoking your Fifth Amendment rights. It's not that you don't understand the question. You understand my question and you're electing to invoke your Fifth Amendment rights, correct?
Yes.
Okay. When Helen or a housekeeper or a house manager, whoever happened to be employed at the time, would take messages, what form would you normally or typically receive them in?
Same objections.
I don't understand the question.
When a caller would call the home, house manager or housekeeper or I don't know what you call her, assistant, would answer the phone and take a message for you so that you would know who called, what would they typically write down the message on so that you would have?
Objection. Objective form, it lacks predicate. You have not established anything here today relative to a housekeeper, a house manager, or the like. And I'm trying to understand your question, but it lacks predicate. Yeah.
Piece of paper is going to play well. Normally they would write it down on a piece of paper and give it to you.
I didn't say that.
Okay. When someone calls the house and you're not the person who answers the phone, let me strike that. Have you ever been given a message that is ripped out of a message pad that has a carbon copy to it?
Oh, I see. Okay, I would like to answer that question, but today my attorneys have advised me I must respond by invoking my Sixth Amendment right, my Fifth Amendment right, and my 14th Amendment rights under the U.S. Constitution, though I'd like to answer these questions. Accordingly, I must assert those rights or I risk losing my representation today.
Between the years 2002 and 2005, who was your house manager? And if there's more than one, tell us that.
The question's unclear, I'm sorry.
Okay, let me start with, between 2002 and 2005, did you employ a house manager?
4. Where?
At your Palm Beach home.
I intend to respond to all relevant questions here today. Hopefully we'll get some. But my attorneys have advised me that today I must invoke my Sixth Amendment, Fifth Amendment, and 14th Amendment rights under the U.S. Constitution. I risk losing them as counsel. So today I will have to assert those privileges.
Do you know
I intend to respond to all relevant questions regarding this lawsuit. However, at the present time, no matter how much I'd like to answer that question, I cannot. Because my attorneys have told me that I have to invoke my Sixth Amendment, Fifth Amendment, and 14th Amendment, or in fact, risk losing their representation. Therefore, I'm going to have to assert my rights under this.
there's a female that was born in July of 1988?
That's a question.
Not yet. When is the first time that you met her?
Objection, speculation.
That assumes that he did meet her. Is that what you're saying?
Your question assumes exactly what you just said, and which has not been established on the record yet, pursuant to the appropriate Florida Rules of Civil Procedure and the Evidence Code. It lacks predicate.
Correct.
That being said, I'd like to answer that question, but today my attorneys have counseled me that I cannot, and they've advised me that I must assert my Sixth Amendment right, my 14th Amendment right, and my Fifth Amendment right. under the U.S. Constitution. Mr. Evans, can you throw me one of those little sucky candies? Please, thank you. Appreciate it.
Isn't it true that you met for the first time in July or August of 2002, just before her 14th birthday?
Same objections. You know, your firm has been accused by the U.S. Attorney of perpetrating one of the largest frauds in South Florida history by crafting sexually charged lawsuits against people like me and others in order to fleece unsuspecting investors here in South Florida out of millions of dollars. The firm of you, Mr. Jaffe. The U.S. Attorney's described it as bogus schemes contrived by your firm. I'd like to answer every one of your questions here today. However, my attorneys have counseled me that I may not, and they've advised me that I have to invoke my 6th Amendment, 5th Amendment, and 14th Amendment rights under the U.S. Constitution. Therefore, that's what I will do. And part was I risk losing their representation.
Isn't it true that Tatum Miller, as a 13 or 14-year-old girl, was taken to your house by another underage minor female, that being Yama?
Form. Tissue, please. Napkin card. Second exhibit. I would like to answer that question like all the other questions you've asked me here today. But today, my attorneys have counseled me that I have to invoke my 6th Amendment right, my 5th Amendment right, and 14th Amendment rights under the U.S. Constitution. Therefore, that's what I will do.
You know who is, right? She had a lawsuit against you previously.
Form. Again, the last name?
No.
Can you spell it for me?
Well, the pseudonym that she used in her lawsuit against you, alleging similar facts to those alleged in LM versus Jeffrey Epstein, was CMA versus Jeffrey Epstein.
Another question?
You know who she is, correct?
Form. I'd like to answer that question here, Mr. But unfortunately today, my attorneys have counseled me that I must invoke my 5th Amendment, 6th Amendment, and 14th Amendment rights under the U.S. Constitution. And if I don't, I risk losing their representation. Therefore, I must assert those rights.
When I asked you about you sat there for a while thinking hard about whether or not you knew them. Do you remember either?
I'm going to move to strike counsel's statement because the statement as worded assumes facts. Certainly not an evidence. It's argumentative. It speculates as to what is thinking hard. And, counsel, I don't understand the question on the table combined with your narrative. So if you could repeat the question.
Sure. I'm asking if during this questioning process, has it refreshed your recollection as to who is, or do you really have no idea who that is?
Form.
Do you remember Tatum?
Are you going to ask one question? Which question would you like to answer first?
Do you remember?
I'd like to answer that question. I'd like to answer that question today. However, my attorneys today have advised me that I must assert my 14th Amendment, 5th Amendment, and 6th Amendment rights under the U.S. Constitution, no matter how much I'd like to answer these questions. So, unfortunately, I'm going to assert those rights.
When you first met, isn't it true that she was just about to begin her 9th grade year in high school?
Same objections. Form.
I believe her testimony in front of the FBI in a sworn deposition says something else, but I don't recall exactly what. I don't have any recollection. Form. You asked the question when I met her. Okay. If I met her.
Okay, so you have no recollection as to when you met her.
I don't have any recollection. If I ever met her, I just told you I did read her FBI statement, so I know what she has said. And that's not what you've just represented to me.
So your only memory of straight up, your only knowledge of any interaction you may have had with is derived from an FBI statement that she gave. Is that true?
I believe what you just represented, she said, was not what she had sworn to.
No, I'm not asking what she said. I'm asking, do you
I think you just
independently remember if she was entering into her 9th grade year in high school when you met her? Independent of anything you read.
Right. Let me just move to strike the diatribe between. I'm confused as to what question's on the table now.
Okay. Independent of anything you've ever read.
Okay.
Do you remember meeting just before she entered into her 9th grade year in high school?
I'd like to answer that question. However, my attorneys today have advised me that though her own statements are contradictory to what you've just said, her sworn statements to the FBI contradict what you've just said, I have to invoke my 6th Amendment, 5th Amendment, and 14th Amendment rights to the U.S. Constitution.
Oh. Just a few minutes ago, when I asked when you met her, you said, I don't know if I've ever met her. So is that your testimony, that you don't know if you've ever met Tatum Miller?
My testimony is very clear. I must assert the rights that my attorneys have asked me to assert today, though her testimony under oath to the FBI is not what you represented it to be to me, and the ladies and gentlemen of the jury who are watching us, hopefully.
Okay. And we'll get into that.
Okay.
When you first came into the room today, didn't you look at me and say, I like the statement that you made to me?
Form. Move to strike.
I don't believe I said that.
What is it that you believe you did say, referencing when you sat down in that seat? prior to the camera phone?
Form. Counsel, I was here during that whole time. I don't recall any such statement.
You're in the room.
I don't remember. I don't know. Sorry.
So is your testimony right now that you did not say to me, I like
Objection.
That's correct. Do you like taking
Form. Frankly. Irrelevant.
I'd like to answer all your questions here as I've tried to do my best. However, my attorneys have advised me that I must assert my 6th Amendment, 14th Amendment, and 5th Amendment rights under the U.S. Constitution.
When you first met, isn't it true that you knew she was a economically disadvantaged girl that needed money?
Objection. Speculation. Assumes facts, not in evidence. And it's argumentative as worded.
I'd like to answer all your questions, okay? However, on advice of counsel, I have to assert my 6th Amendment, 5th Amendment, and 14th Amendment rights under the U.S. Constitution. Or losing those, my right to effective representation. So accordingly, I must assert those rights as guaranteed by the 6th, 5th, and 14th Amendment.
And when she was a 14-year-old girl, she was taken into your bedroom and you ordered her to take her clothes off. Is that correct?
Objection. Vague. Confusing. As to her, I'm not quite sure who you're...
Okay. When was a 14-year-old girl, she was taken up to your bedroom and you ordered her to take her clothes off. Isn't that true?
Objection. Speculation. It assumes facts, not in evidence. Lacks predicate.
Though, once again, what you just represented to me is in total contradiction to the FBI sworn statement that I read of Tatum Miller, I must unfortunately respond by asserting the rights demanded by my attorneys today, which is my 6th Amendment, 5th Amendment, and 14th Amendment right, given by U.S. Constitution. Though her testimony is exactly, does not purport in any way to what you just said.
And when was 14 years old, you ordered she begin to give you a massage while she was naked and you were naked. Isn't that true?
Same objections.
Sorry, you have to repeat the question.
Well, Tatum was a 14-year-old girl.
Right. Yes.
You laughed and said, right. About what?
No, I didn't hear the first part of your question, so now I understood it.
Okay. When was a 14-year-old girl, isn't it true that you received a massage from her while she was naked and you were naked?
Objection. Speculation. Assumes facts, not in evidence. Predicate. Lacks predicate.
I understand that your firm has been accused by the U.S. Attorney of South Florida of perpetrating one of the largest frauds in Florida's history by crafting malicious, sexually charged allegations against people like me. I understand that Ms. Miller's testimony is not that what you've just described, though she swore to the FBI that under oath. And though I'd like to answer your questions here today, my attorneys have advised me I may not. I must assert my 6th, 5th, and 14th Amendment rights under the U.S. Constitution, or risk losing that representation. Restroom break.
Excuse me?
Restroom break.
All right, we're stopping again.
Going off the video record at 1:49 p.m. We're back in the video record at 2:04 p.m.
Mr. Epstein, when was a 14-year-old girl, isn't it true that while you were naked on the massage table, you ordered to take off her clothes and provide you a massage?
I believe I've answered the question.
I don't know where we left off, that's why.
Form. Argumentative. Speculation. Compound. Assumes facts, not in evidence. And procrastination. But we did take a break.
So the current U.S. Attorney has described your law firm, Mr. Edwards. The current U.S. Attorney has described your law firm as a criminal enterprise involved in fabricating sexually charged cases against people like me in order to fleece unsuspecting investors out of millions of dollars. You used words like bogus schemes. Unfortunately, at this time, in response to your questions, though I'd like to answer each and every one, I'm going to have to, on advice of counsel, assert my 6th Amendment, 5th Amendment, and 14th Amendment rights under the U.S. Constitution. Though I'd like to answer those questions.
A naked 14-year-old girl providing you a massage, you ordered her to pinch her nipples during that massage. That's true.
Same objections. Argumentative. Speculation. Harassing. Assumes facts, not in evidence, and lacks predicate.
I asked her to pinch her nipples.
Pinch your nipples.
I believe her own sworn testimony contradicts that statement, however, and I'd like to answer all your questions here today. But my attorneys have advised me that, at least today, Mr. I must take my constitutional privileges of the 6th Amendment, 5th Amendment, and 14th Amendment, keeping in mind that your firm, you and Mr. Edwards and Mr. Jaffe here, his firm has been accused by the U.S. Attorney of perpetrating one of the largest frauds in Florida's history by crafting sexual charged lawsuits against people like me to fleece from local people millions of dollars.
And during this massage by Tatum Miller, you began to masturbate in front of her. Isn't that true?
Same objections.
Again, unfortunately, I'd like to answer each one of your questions here today. My attorneys have counseled me that today, at least, I have to assert my Fifth Amendment, Sixth Amendment, and 14th Amendment rights under the U.S. Constitution. Otherwise, I risk losing their effective representation. And the fact that your firm has been accused of fabricating these malicious lawsuits to fleece investors out of millions of dollars and described by the U.S. Attorney here in South Florida as a criminal enterprise involved in mail fraud, money laundering. Unfortunately, I'd like to answer each question, but I can't today.
Isn't it true that while you were masturbating, you inserted your fingers into her 14-year-old vagina?
Objection. Argumentative speculation. It's harassing. It assumes facts not in evidence. And the question continues to lack predicate. And I also believe the question is asked and answered some time ago.
Though I'd like to answer each one of your questions today, Mr. My counsel has told me I cannot answer any questions that may be relevant to this lawsuit. The fact that your firm has been accused of major fraud, the largest fraud in South Florida history by the U.S. Attorney, calling your firm a criminal enterprise involved in money laundering. I believe it's racketeering, but I could be wrong. Monetary transactions, wire fraud, mail fraud, conspiracy. Sorry. I'd like to answer your questions, but today, on advice of counsel, I'm going to have to assert my rights.
And isn't it true also that while was a 14-year-old female, you...
Same objections incorporated.
Again, the question.
Isn't it true that during this sexual massage, while you were that you masturbated to the point of...
Argumentative speculation. It's compound. It's vague. It assumes facts not in evidence. And lacks predicate.
Though I'd like to answer that question with specificity and detail today, no matter how much I'd like to, my attorneys advise me I cannot. They advise me I must assert my Fifth Amendment, Sixth Amendment, and 14th Amendment rights under the U.S. Constitution, or potentially lose effective representation, so therefore I will assert those rights.
Isn't it true that the ritual that I'm describing occurred with approximately 100 times when she was between the ages of 13 and 16?
Same objections with the additional objection of vague and confusing.
Since your firm has been involved, according to the U.S. Attorney, in crafting these fraudulent lawsuits in order to fleece local investors, and the fact that I believe in Tatum Miller's sworn statements, that's what you've just alleged, at least, is totally contradicted by your client's own sworn statements. Though I'd like to answer these questions today, my attorneys advise me I may not, and they advise me I must assert my Fifth, Sixth, and 14th Amendment rights under the U.S. Constitution, but potentially risk losing effective representation.
In addition to the sexual abuse directly against Tatum that I just described, isn't it true that you also paid her money to bring you more than 50 other underage minor females for you to similarly abuse?
Same objections.
Excuse me. Though I believe in her own sworn testimony to the U.S. government, she contradicts your assertions. And I'm sure that maybe you'll have some explanation at trial. But ladies and gentlemen, the jury should know about your firm being accused by the U.S. Attorney of perpetrating one of the largest frauds in U.S. history by crafting malicious lawsuits of a sexual nature in order to fleece investors out of millions of dollars, local investors. And though I'd like to answer your questions in detail today, my counsel says I may not, and they've asked me to assert those rights, which I must, unfortunately.
You keep bringing up this fraud of the former law firm known as... In response to my question, so I'd like for you to tell the jury at this time, which allegation are you now saying is fraudulent or untrue that is being made by...
Form, confusing, compound, and irrelevant.
It's only made relevant by his answers.
Same objections.
You understand the question?
No.
Okay. You made reference to this in response to my questions about what you did sexually to... As you have responded with these fraud allegations against the firm of Rothstein, Rosenfeld, Adler. I want you to tell the jury which allegations that is making against you are you disputing at this time or calling a fraud or calling untrue?
Confusing, compound, and if the court would read back Mr. Epstein's response, I think you will see that the way you just phrased the question mischaracterizes his testimony. Because, I'm going to keep it there, unless you want me to go further?
No, I want him to go further.
Mischaracterizes witness's testimony.
His own statements contradict every one of your allegations that you've made to me today. It is a hypothetical, in her own words, and the potential reasons that concern me is the fact that the law firm that represented and two others have been accused by the U.S. Attorney of fraudulently producing cases against me and others to fleece investors in what he's described as one of the largest frauds in South Florida's history. So it concerns me. It's a factor in the way I'm thinking about answering. Sorry.
Each time that you paid her $200, is that correct?
Objection. Argumentative. Speculative. It's harassing. It assumes facts, not in evidence. And with regard to this line of questioning, the court has already ruled that the demeanor in which you're presenting this question is improper and harassing. So if you would...
I'm very comfortable with the demeanor right now.
If you would...
Mr. Pike. These are just the facts of the lawsuit. The facts are outrageous, and I understand that, but they have to be asked.
Maybe the demeanor and tone of your question is laced in a manner that it's proper for the video, but the content of the question is the same exact harassing question that was deemed by the judge to be argumentative. I'm not saying that he's not going to answer your question, or that you don't know what his answer is going to be, but what I'm saying is, could you rephrase the question?
To answer that question, I'll work on rephrasing it for you.
I'm sorry, I forgot what the question was right now.
Isn't it true that each time that you interacted with you paid her $200 each time?
I'd like to answer... Sorry?
Go ahead.
I'd like to answer each one of your questions here today. However, my attorneys have counseled me that today I have to assert my Fifth Amendment, Sixth Amendment, and 14th Amendment rights under the U.S. Constitution. And I'm cognizant of the fact that your firm has crafted these malicious lawsuits. It's been reported that the lawsuits are of a sexual nature in order to fleece investors. So, though I'd like to answer those questions, Mr. I must keep my counsel's advice.
And isn't it true that for each underage minor that brought to you for the purposes of you engaging in sexual activity, you paid her $200?
Objection, speculation. It's a compound question, and it assumes facts, not in evidence, and therefore lacks predicate.
Though I'd like to answer that question, as most of the other questions here today, I intend to respond, hopefully at some point, to all your questions, but today my attorneys have advised me I must invoke my Sixth Amendment, Fifth Amendment, and 14th Amendment right under the U.S. Constitution.
So over the course of relatively, roughly 3 years, isn't it true that you touched or fondled in a sexual manner on more than 50 occasions?
Objection, argumentative, calls for speculation. It's overbroad, confusing and vague, and it assumes facts and not in evidence.
Could you repeat the question? I'm sorry, this wasn't...
Yes, the 3-year period between 2002 and 2005, when you were engaging in sexual conduct with isn't it true that that conduct took place on more than 50 occasions?
Same objections.
Okay, I believe if you read your own client's FBI statements, that when her statement changed dramatically after she decided to file a different lawsuit at the request of you and your firm, one of your firms, and there's been many firms, it seems, who've been accused of major fraud. Since her testimony has changed dramatically, I would like to answer those questions, but today, my attorneys have advised me I must assert my Sixth Amendment right, my Fifth Amendment right, and my 14th Amendment right.
Well, your answers are not going to incriminate you if the answer is no. It's only if the answer is yes that it's going to incriminate you. So aren't you telling the jury that every single thing that I've asked you, it's not part of a fraud, it just happens to be true?
Objection, argumentative, irrelevant, and move to strike. And I'm just simply going to instruct the witness not to answer that question because I don't understand it. I don't know what to say about that question.
Well, all of the things that I've told you, or that I've asked you about, you touching her while she was underage, you paying her for sexual conduct, those are all things that really happen. There's nothing about that anybody's fabricated or made up, is there?
I'm going to object. It's argumentative, speculative. It assumes facts, not in evidence. It certainly mischaracterizes the witness's testimony all day since I've been here, and I've been here the whole time. And it assumes facts and not in evidence. And it's also overbroad and substantially compound because you're attempting to incorporate all of your questions today into one question.
I think that you know, Mr. Beck, that your objection should be limited to the form. And if you object to the form...
Okay, I'm sorry. You've asked me several times here today to tell you why, and I thought I was helping. I'm sorry. But I certainly will keep objecting to the form.
Thank you. And your answer is?
You have to repeat the question.
Every single allegation that has made and that I have now questioned you about in terms of your sexual involvement with they are all true. Isn't that correct? I mean, there's nothing fabricated about any of these allegations.
Objection, argumentative, speculative, compound. It's vague, overbroad.
You object to the form?
Assumes facts, not in evidence, and lacks credit. That is form.
And I would like to answer that question specifically today. However, on advice of counsel, they've suggested I take the Sixth Amendment, assert my Sixth Amendment, Fifth Amendment, and 14th Amendment rights under the U.S. Constitution, keeping well aware of your firm's responsibility in the largest fraud in Florida's history by crafting sexually charged lawsuits against people like me and others. I believe, in addition, since her allegations, as you phrased them, have changed dramatically since her sworn statement until, in fact, after she joined the most of her statements have changed. I believe. So,
You remember when Tatum Miller became pregnant when she was 16 years old, don't you?
Form, relevance, and move to strike.
I would like to answer each one of your questions here today, Mr. Edwards. Each and every one of your questions. However, today my counsel has told me I must assert my 6th Amendment, 14th Amendment, and 5th Amendment rights under the U.S. Constitution.
And isn't it true that when Tatum Miller was 14 years old, 15 years old, and 16 years old, you touched her genitals?
Separate from the fact that in her own testimony, her own sworn testimony under oath before she decided to file a lawsuit for money, there was never any discussion about anything like that. I would like to answer that question, but my attorneys advised me, at least today, that I must assert my 6th Amendment, 5th Amendment, and 14th Amendment rights under the U.S. Constitution.
And isn't it true when she became pregnant at age 16, you no longer interacted with her sexually, but still demanded that she bring you other underage minor females for you to sexually exploit?
Objection, speculation, compound, harassing, and assumes facts not evidence.
I believe her testimony changed dramatically from her sworn statements to the FBI.
That's not a responsive answer. It's not a responsive answer. So I'm not going to let him answer as to her. We'll move to strike it. But let's answer the question.
It's fine. Witness is tried. If there's a legal, basis for your, if there's a legal basis for your moving to strike, then it'll be taken up with the court, and you can move to strike.
Strike it as non-responsive.
You can continue.
Fine. Since the allegations that you keep throwing at me relate to the fact that Mr. Miller's testimony, after giving a sworn statement to the FBI, changed dramatically after she decided to file a lawsuit for money, joining your firm that's been accused by the U.S. Attorney of one of the largest frauds in Florida's history. I would like to answer those questions. However, on advice of counsel today, I must assert my 5th Amendment, 6th Amendment, and 14th Amendment rights under the U.S. Constitution.
And when Tatum Miller was a pregnant 16-year-old, she brought you at least 10 underage minor females during her pregnancy. Isn't that true?
Objection, argumentative, speculation, it's vague, and assumes facts not in evidence and lacks predicate.
I unfortunately would like to answer that question as well as every other question you've asked me here today. But my attorneys have advised me that I must assert my 5th Amendment, 6th Amendment, and 14th Amendment rights under the U.S. Constitution.
And after Tatum Miller had her son at 16 years old, and you were being criminally investigated for some of the conduct that we've discussed here today, isn't it true that you personally hired and retained and paid for an attorney to represent Tatum Miller?
Objection, speculation,
Objective form.
compound. I will not. I'm allowed to assert the basis for my objections. I'm not limited to just saying form. I'm able to assert the basis as to why, so I don't waive that basis.
It's just more of this obstructionist.
It's not obstructionist. It's objecting to form. And what's obstructionist is what we're doing right now. I'm going to be finished within 4 seconds. So I'm going to object to form. It's argumentative. It's speculative. And it assumes facts not in evidence, and it lacks predicate. That's it.
I'm sorry. Again?
The response.
I know, but I don't know the question.
You don't remember the question about hiring? Did you hire Tatum Miller an attorney at some point in time? You remember that?
Same objections.
Not to the best of my recollection.
You know James Eisenberg?
Do I know James Eisenberg? I don't believe I've ever met James Eisenberg.
Is it your testimony today then that you never paid for an attorney to represent Tatum Miller?
On advice of my counsel, I'd like to answer that question, but on advice of counsel, I'm going to have to assert my 6th Amendment, 14th Amendment, and 5th Amendment rights against, 6th Amendment rights of the U.S. Constitution.
And that attorney that was paid for by you informed Tatum Miller that if she were to tell the FBI exactly what happened at your house, that her son could be taken from her. You're aware of that, right?
Same objections.
I recognize that, I believe she made that one of the statements under her deposition after she decided to sue me for a bunch of money. And your firm has represented a number of cases of a sexually charged nature that turned out to be fraudulent in order to fleece local investors. The U.S. Attorney described your firm and these cases as a bogus scheme. I'm aware of that, and I'd like to answer your question in more detail today, Mr. Edwards. However, my attorneys advise me that at least today, I must assert my rights under the 6th Amendment, 14th Amendment, and 5th Amendment.
Come in.
Food?
It's the food.
Everyone can be walking in the room with a deposition and get in.
Absolutely. I agree.
All right.
You ready?
Hey, you want to break now?
Sure.
So.
Okay, thank you.
Going off the video record at 2:29 p.m. We're back in the video record at 2:50 p.m.
Isn't it true, Mr. Epstein, that you gave Tatum Miller money to coerce her into interacting with you sexually?
Mr. Edwards, I would like to answer each and every one of your questions here today, but unfortunately, as I've done with mostly all your other questions, I'm going to have to assert my rights under the 6th Amendment, 14th Amendment, and 5th Amendment on advice of counsel. And though I would like to answer it, if I ignore my attorney's advice, I risk losing my representation.
In committing these sexual acts against Tatum Miller when she was just a minor, you knew that it would psychologically damage her. Isn't that true?
Form. Speculation.
I intend to respond at some point to each one of your questions.
Excuse me.
I'd like to respond to each and every one, but today, on advice of my counsel, they required me to assert my 5th Amendment, 6th Amendment, and 14th Amendment rights under the U.S. Constitution, though I'd like to answer each one of these questions.
In fact, you deliberately and intentionally caused severe emotional distress to underage minor females, including Tatum Miller. Isn't that true?
Objection. Argumentative. Speculation. It's compound. And it assumes facts, not evidence.
I would like to answer that question as I'd like to answer all your other questions today regarding Tatum Miller. However, my attorneys today have advised me that I must assert my 6th Amendment right to effective representation, and my 5th Amendment right, and my 14th Amendment right. So, though I'd like to answer that with specificity, I must follow my attorney's advice.
Will you admit for the jury that you were investigated federally for your illegal activities with underage minors?
Same objections.
I'd like to answer that question as well as all the other questions you've asked me here today. Especially since your firm has been accused by the federal government of being considered a criminal entity. Your firm has been considered and investigated as being a criminal enterprise, using fabricated cases, to fleece investors out of millions of dollars. But I'd like to answer your questions, however, my attorneys have demanded that I assert my rights under the 6th Amendment, 5th Amendment, and 14th Amendment.
In fact, as a result of that investigation, you, as well as the United States Attorney's Office, entered into what has now been known and referred to as the non-prosecution agreement. Isn't that correct?
Same objection. The document speaks for itself.
You have to repeat the question.
Yes, as a result of the criminal investigation into your activities with minor females, you reached a resolution with the United States Attorney's Office in what has now been described as the non-prosecution agreement. Is that correct?
I object. It's vague, confusing. Misrepresents the agreement in the documents. The best evidence. Want to mark it?
Yeah, we'll mark it. I think I can mark this copy. And we'll copy it at the end and we'll mark it as Exhibit 2.
Yes.
And in that agreement, there are listed co-conspirators of Jeffrey Epstein, those being Sarah Kellen, Adriana Ross, Leslie Groff, and Nadia Marcinkova. Can you explain to the jury what those 4 individuals did for you related to the crimes that were investigated by the federal government?
Does it say co-conspirators?
Yeah, it says criminal charges against any co-conspirators of Epstein, including, but not limited to, Sarah Kellen, Adriana Ross, Leslie Groff, or Nadia Marcinkova. Can you explain to the jury what each of those 4 individuals did for you or conspired with you to do?
I'm going to object to the form of the question.
Okay.
I'd like to answer that question. However, today, my attorneys advised me that I must assert my 6th Amendment, 5th Amendment, and 14th Amendment rights under the U.S. Constitution.
And isn't it fair to say that you, as well as the co-conspirators, operated as an organized criminal enterprise designed to sexually exploit underage minors?
I'm going to object to argumentative speculation. It's vague, and it assumes facts, not evidence.
Are you suggesting it was a criminal enterprise, you said?
Yes.
Is that the word? I know.
Yes.
Though I'd like to answer that question today, I think the only criminal enterprise that I've been reading about today was your firm that's been accused of being a criminal enterprise involved in defrauding people, using mail fraud, wire fraud, money laundering, the operation of the enterprise. This is by the U.S. Attorney. But though I'd like to answer your questions with specificity today, on advice of counsel, though I'd like to answer it, they demanded that I assert my 6th Amendment, 14th Amendment, and 5th Amendment right, therefore, unless I risk losing their representation.
Did you care about any of the underage minor females at the time when you were engaging in sexual conduct with them?
Objection. Argumentative. Harassing. Already been ruled upon by the court relative to this exact question.
I feel comfortable with the question. It goes to punitive damages. This is obviously the issue related to the court was a repetitive question on that topic or around that general subject matter. And I'm just asking for Mr. Epstein to tell the jury how he felt about these girls, whether he cared about them when he was engaging in illegal sexual conduct with them.
Counsel, I'm going to instruct him not to answer the question. You can certify it to the court if you like. You know what the answer is going to be. However, you're attempting to lace this video. You know that the court has already ordered that these types of questions are not permitted because they're argumentative and they're harassing. And in fact, the other question's ordered, but this question is on exact point with the court's order. So if you want to withdraw the question, that's fine.
No, I don't want to withdraw the question.
Okay, well, then I'm going to instruct him not to answer.
That's fine. Let's mark that somehow, that page, so that we can find it in the record, relative to the hearing that will be had on that question and others similar. At the very least, you certainly knew that engaging in sexual conduct with underage females was not, well, to strike that. At the time when you were engaging in sexual conduct with underage females, you knew that exposing them to this was not beneficial or good for these girls. Isn't that true?
Objection, argumentative, speculation. Assumes facts not met, that's lacks predicate.
Though I'd like to answer that question like most of your other questions here today, on advice of counsel, I must assert my 14th Amendment, 5th Amendment, and 6th Amendment rights. And though I'd like to answer, if I do so, I risk losing my effective representation of counsel.
Isn't it true, Mr. Epstein, that the only thing that you cared about was accessing as many underage females as possible for the purposes of sex?
Argumentative, speculation. It's harassing.
What's the question?
And assumes facts not met.
Isn't it true that the only thing that you cared about when you were interacting with these underage females in a sexual manner was ejaculating or your own personal gratification?
Four same exact objections.
Though I'd like to answer that question, and to the ladies and gentlemen of the jury, I'd very much like to answer that question. However, today, my attorneys advise me I must assert my rights under the 14th, 6th, and 5th Amendments of the U.S. Constitution, unless I risk losing the representation.
And Mr. Edwards, just so we don't have to come back on the question that I instructed him not to answer, if you'd go ahead and repeat that question, I'd be more than happy to let him respond.
I don't remember the question. We'll take it up to the court. We'll get a ruling on it.
That was whether or not he cared about these. I believe he's quoted it as underage minors, but I would like the court reporter to read back the question just to conserve judicial resources and not go back. So if she could reread the question, that would be good.
If you can find the question. So. I think I know. Yeah. Did you care about any of these underage minor females that you were engaging in sex with at the time when you were engaging in these sexual activities?
Same objections as before.
Though I'd like to answer that question as well as most of your other questions, if not all your other questions here today, on advice of counsel, I'm going to have to assert my 14th Amendment right, my 6th Amendment right, and my 5th Amendment right. Because no matter how much I actually want to answer that question, if I do so, I risk losing my counsel's representation.
Sorry. At the time you were engaging in sexual activity with these underage minors, including Tatum Miller, you knew that this conduct was illegal, didn't you?
Same objections.
I'd like to answer that question, as well as most of your other questions here today. However, today my counsel is instructing me to assert my 14th Amendment, 6th Amendment, and 5th Amendment right. And if I do not, in fact, if I answer that question, if I can answer that question, I potentially risk losing my effective counsel representation.
In fact, you told many of these underage minor females not to tell anybody what happened with you in the house, or else they would be in trouble. Isn't that true?
So, I'd like to answer that question as well as the other questions. However, my counsel has advised me that today I must assert my 14th Amendment, 6th Amendment, and 5th Amendment rights under the U.S. Constitution.
And in fact, those underage minor females that have pursued cases against you and have come forward with what happened inside your house, you have, strike that, the underage minor females that have come forward with information about your sexual interactions with them have been investigated, harassed, humiliated in an effort for you to intimidate them to go away. Is that true?
Objection. Argumentative, speculative, compound, it's overbroad, and assumes facts not met.
Can you repeat the question?
Sure. Any underage minor female that you engaged in sexual activity with and that has now pursued a lawsuit against you, isn't it true that you spent a lot of money and a lot of resources investigating them in an effort to intimidate them and hopefully make them go away?
Same objections.
I believe your client's testimony changed dramatically when she joined up with you and your law firm accused of fraud. When she decided to change her testimony, at least from what these statements said, both to the police and to the FBI, and decided to seek money. However, anything above that or beyond that, I'm going to have to, in fact, assert my 5th Amendment, 6th Amendment, 14th Amendment rights as directed by my competent counsel. Unfortunately, they have told me that if I don't, I risk losing their representation.
All right, I'm going to give you a chance here since you keep bringing up her statement to the FBI as opposed to her sworn testimony for 13 hours under oath in this case. Are you saying that the sworn testimony to the FBI was in fact the truth?
What I'm saying is it seems her testimony has changed dramatically after she joined your firm. That's all.
Okay. Irrespective of her testimony, you've read her testimony and you to the FBI. You've watched her deposition when it was being taken. Which
You're making assumptions. I'm sorry. So
You just go ahead and let him finish the question,
my fault.
and then I'll object, and then you'll respond.
which are you saying is the truthful testimony? Her statement to the FBI or the videotape deposition that you watched?
I'm going to object for him.
What I've said, and I thought I'd repeat myself, is that until she joined your firm and started to seek money, her testimony was different. That's my understanding. Sorry.
Are you denying any sexual involvement with Tatum Miller at this time?
I'd like to answer that question. I'd like to answer most of your questions here today. However, my attorneys have advised me that I must assert my rights under the 6th Amendment, 14th Amendment, and 5th Amendment, no matter how much I'd like to answer that question. Or, potentially risk losing my counsel.
Isn't your game plan with all of these civil lawsuits that have been filed against you to spend as much money as you can to investigate and harass these young women into hopefully dropping the lawsuits against you?
Objection. Irrelevance. Move to strike. So it's argumentative. It's harassing.
I'd like to answer that question. I think you know the answer to that question.
Yes.
However, today, my attorneys have advised me I must assert my 6th Amendment rights, my 14th Amendment rights, and my 5th Amendment rights.
And recently, strike that. You don't have any remorse for the sexual abuse that you committed against Tatum Miller, do you?
Objection. It's argumentative. It's harassing. It's, I believe, confined underneath the judge's order. And it assumes facts, not an evidence.
That being said, I'd like to answer that question today. But my attorneys have advised me that I must assert my 14th Amendment rights, my 5th Amendment rights, and my 6th Amendment rights.
In fact, you recently sued Tatum Miller, didn't you?
Yes.
Okay.
And you and your firm that's been accused of the largest fraud in Florida's history, described by the U.S. Attorney as a criminal enterprise involving money laundering, conspiracy to commit mail fraud, conspiracy to commit wire fraud. Yes, I sued you, your firm, and Tatum Miller.
Tell the jury the basis or the evidence that you have to support the allegations in the complaint against Tatum Miller.
Okay. I'm going to instruct the witness not to answer that question in this medium, as it is wholly irrelevant currently as worded to this particular lawsuit.
Just so that you can rethink that position, the lack of remorse goes to punitive damages that is an aspect of the case that Tatum Miller has against Mr. Epstein.
This lawsuit, current one that Mr. Epstein is noticed for, and the lawsuit in which Mr. Epstein has filed against the former Rothstein Roosevelt Mallard, Tatum Miller, and Mr. Brad Edwards, is not proper for this medium.
I understand your position.
In that regard, I'm going to instruct him not to answer any questions relative to that lawsuit because of that objection, as well as it is my understanding that Mr. Scarola has set Mr. Epstein's deposition, I believe, either early next week or mid-March, on the case of Epstein versus RRA, Rothstein Roosevelt Mallard, Mr. Edwards, as well as Tatum Miller. Therefore, when that time approaches, that will be the appropriate time for those type of questions related to that lawsuit.
I understand your position completely, Mr. Pike. But as it relates to, obviously, Tatum Miller sued you, making the allegations that you sexually molested her from when she was 13 years old to 16 years old, and now you've sued her in something that is seemingly related to that case. And I just want to understand what your factual basis is or what evidence you're using to support your lawsuit against Tatum Miller so that the jury can evaluate whether that is evidence of lack of remorse that would go to punitive damages claims that Tatum Miller has against you.
And I would instruct him not to answer that question for the same reason stated.
Let's mark that. Is it your feeling that because you are wealthy and these children are poor, that you are entitled to sexually abuse them?
Argumentative.
And speaking about these children, including Tatum Miller.
Argumentative, speculative, it's compound, it's vague, it assumes facts, not evidence.
Yes, and in keeping with your firm's propensity to file fallacious, manufactured, sexually charged cases based on nothing but thin air, accused by the U.S. Attorney of the largest fraud in South Florida's history by manufacturing sexual cases, I would like to answer each and every one of your questions, including why I sued you. But today I'm not going to be able to. So I'm going to have to simply listen to my counsel and assert my 6th Amendment, 14th Amendment, and 5th Amendment right.
And this answer that you keep reciting about the Rothstein Rosenfeld Adler firm.
You do know who they are, right?
you are aware, obviously, that all of the lawsuits that were filed against you, including were filed at least a year before, or approximately a year before Rothstein, Rosenfeld, Adler had any of these cases. You're aware of that, right?
I do not know when Rothstein and Adler got involved in these cases. I do know that the moment they did surface, in fact, I understand that you shared information with all the other attorneys that you so like, and the jury should understand that the information gathered, according to the U.S. Attorney, by illegal means, has been shared with all the other attorneys that you keep representing and filed cases against me. Yes, I'm aware of that.
I don't understand that answer. Excuse me?
Do you have a question?
Yeah, I want to understand what his answer is, which is familiar in every single deposition.
No.
If you don't understand the answer, clarify the answer.
No, you have to ask a question.
I did, and he's responding to it.
The witness has answered the question. Do you have another question to clarify his answer?
Yes, please clarify your answer.
I'm going to instruct him not to answer. I don't know. It's vague and confusing. It's narrative.
Me saying clarify your answer is narrative?
Yeah, what do you mean clarify the answer?
I didn't hear what he said. Say it again so I can hear it.
Would you please read back what Mr. Epstein just testified to, Madam Court Reporter?
This answer that you keep reciting about the Epstein, Rosenfeld, Adler firm, you do know who they are, right? Question, you are aware, obviously, that all of the lawsuits that were filed against you, including LM, were filed a year before, or approximately a year before Epstein, Rosenfeld, Adler had any of these cases. You're aware of that, right? There's an objection stated on the record. I do not know when Epstein, Adler got involved in these cases. And the witness goes on to say that the information surfaced, and I understand you shared information with all the other attorneys that you so the jury should understand. The information gathered, according to the U.S. Attorney, by illegal means, was shared with all the other attorneys that you keep representing and filed cases against me. Yes, I'm aware of that. I don't understand.
Okay.
So there was an answer, a question.
Mike, I understand. Okay. I don't understand the answer, but now I know the answer.
Okay.
At this point in time, please tell the jury, what is your defense of the claims being asserted against you in this lawsuit by
I'm going to object. Calls for a legal conclusion.
What are the claims? So since you're representing Tatum Mill, can you tell me what the claims are?
Yeah, we've gone through it. She went to your house when she was 13, 14, 15, 16 years old.
Is that a claim?
She was in your bedroom. You instructed her to get naked. You coerced her into recruiting other underage minor females, roughly 50 or so more. Now, these are all claims that have amounted to various counts: coercion into prostitution, intentional infliction of emotional distress, battery, committing various crimes against her. What are your defenses to that? I mean, normal defenses are, I didn't do it. I did it, but it didn't hurt her. And we're trying to understand, so we understand how to provide this case to the jury. What are your defenses to these allegations?
I'm going to object to this line of questioning. It's compound. As worded, it could call for the disclosure of attorney-client information as well as work product. And I believe in this particular case, there is a document filed, answering affirmative defenses, and those affirmative defenses are set forth in the document there. Speaks for itself.
Okay. Respond.
The document speaks for itself.
So you agree with the affirmative defenses that were filed in your case? If you were to testify, we could expect that to be your testimony?
That's not what the witness testified to. The witness testified that the document speaks for itself. And again, I'm going to object to attorney-client, work product, and instruct the witness not to answer.
Okay, I'm not asking what your legal defense is. I'm asking what is your response to those claims? What is your personal response?
I'd like to respond to that question. I'd like to respond today to that question. However, today my attorneys have told me that I cannot respond. They've asked me to assert my 14th Amendment, 6th Amendment, and 5th Amendment rights of the U.S. Constitution, though I would really like to respond, but they told me that if I did so, I lose risking their representation.
Okay. I know you've invoked your 5th Amendment rights related to many of these questions, but isn't it true that you recently contacted at the New York Daily News and spoke with him about case as well as several of the other girls who have claims against you?
Who?
New York Daily News.
Can you repeat the question?
Didn't you recently, within the last year, contact the New York Daily News and discuss these cases that have been filed against you and the allegations made by these various females?
I'd like to answer that question, but unfortunately today, my attorneys have advised me I cannot. They advised me I must assert my 14th Amendment, 6th Amendment, and 5th Amendment right. So therefore I will do so.
Why is it that you will talk to about this, but you will not talk to the jury about this?
Form, argumentative, speculation, it misstates the witness's testimony, it assumes facts, the question assumes facts not in evidence, and now it lacks predicate.
Sorry, who's
reporter with the New York Daily News? Did you not talk to him? If you didn't talk to him, tell me that. It's fine.
Same objections.
I'd like to tell you answers to each one of your questions. However, today, my attorneys have demanded that I respond by asserting my 14th Amendment, 6th Amendment, 5th Amendment privilege. so I'd like to respond. But they said if I do so, I risk losing their representation.
Didn't you tell that these underage minors were not victims at all, and that regardless of their age, you did not personally consider them victims?
Same objection.
Did I tell them? I'd like to answer that question, but today, on advice of my counsel, I must, as I've done with mostly each one of your questions, I have to assert my Fifth Amendment, Sixth Amendment, and 14th Amendment rights under the U.S. Constitution.
You were 51 when was 14 and you were interacting with her sexually. Is it your testimony that despite the disparity in age, you do not consider to be a victim?
Argumentative speculation assumes facts not in evidence. It's compound. Relax, break it.
Not only does it contradict your own client's statements to the FBI and the sworn testimony, I would like to answer that question. Hopefully one day I can answer that question, but today my attorneys have said I cannot. And then they advised me I must assert my Sixth Amendment, Fifth Amendment, and 14th Amendment rights.
In the last 10 years, what is the youngest underage minor female that you have interacted with sexually?
Argumentative speculation assumes facts not in evidence.
Excuse me. The answer to that question is something. I'd like to give you an answer to that question today, but my attorneys have advised me I must assert my 14th Amendment rights, my Sixth Amendment rights, and Fifth Amendment rights.
Do you know
Okay.
former housekeeper or employee of yours worked at your at the Palm Beach house?
Could. Don't know.
Okay, so you would be unable to answer what did for you.
Yes.
Okay. Are you aware that our investigators spoke with former housekeeper for you or house manager for you out in California? Okay.
No.
Any reason why, when asked about the activity that occurred in your house, he would tear up and say, "I was hoping to forget everything I saw"?
Objection. Argumentative. Speculative. That assumes facts not in evidence.
Again, question.
Is there any reason that when asked,
I don't know who he is.
It's also hearsay.
Fine.
Going off the video record at 3:23 p.m.
3:39, break it 4, gets me up. 1 second, please.
Oh, maybe not.
No, it's not-
We're back on the video record at 3:30 p.m.
And this person that I asked you about, is that somebody who has contacted you within the last 6 months?
No.
Okay. And in taking a break and thinking about some of these questions, have you remembered who that person is, or still no real memory of him at all?
Don't remember.
Best of your knowledge, he never worked for you.
Well, not that I can recall. But there's lots of people who work for me, so
Okay. Can you tell the jury who the various people are that work for you now?
I believe I answered that question already.
In that you invoked your Fifth Amendment, that's correct? Have you...
Sixth Amendment and 14th Amendment.
18th and 21st.
Move your strike.
Okay. Have you during this litigation, and by this litigation I don't only mean case, I mean the various other lawsuits that have been filed against you by other females alleging sexual misconduct by you against them, who have you retained attorneys for? What witnesses have you retained attorneys for?
Okay.
I'm going to object to form,
Okay.
and I'm going to instruct them not to answer because I don't understand the question.
Great.
Okay.
All right. During this civil discovery and litigation, have you paid for and or retained an attorney for any other witnesses?
Any other witnesses?
Yeah, like I'll give you an example that you may, just to refresh your recollection or tell you what I'm talking about. Luella Roboyo, you know who that is, right?
Yes, sir.
Okay, she's somebody who works for you now. She's a housekeeper. We took her deposition already. That's at least what her testimony was.
Form. I'd like to answer that question, but I'm going to have to assert my Sixth Amendment, 14th, and 5th.
Okay.
Okay, sorry.
That's somebody who has informed us that you paid for and retained an attorney by the name of to represent her during this process. Is that true?
Form. I'm going to have to assert my Fifth Amendment, Sixth Amendment, 14th Amendment.
Right. Other people that have indicated that you retained and paid for an attorney to represent them are... Have I missed anybody else that during this litigation you've paid for or retained attorneys?
Form, same objection.
I'm unclear. Are you suggesting I've paid for attorneys for all these people?
Yes.
I'd like to answer those questions today, but on the advice of counsel, I'm going to have to invoke my Sixth Amendment, Fifth Amendment, and 14th Amendment right.
And if you have not, tell me which of those on that list that you have not paid for or retained an attorney for.
Same objection. Same answer.
You're invoking the Fifth Amendment, right?
Sixth Amendment, 14th Amendment.
Okay.
And Fifth Amendment.
And is it a company or is it you personally that is paying for the attorney's fees related to your representation?
Okay. I'm going to object to form. I'm going to instruct them not to answer that question based on relevance. And it's vague. It's vague also.
Okay. Who is writing the check to your attorneys for your representation in this lawsuit? Who's paying the bill?
I believe I am.
And is it you personally, or is this one of your corporations or companies?
Form speculation.
I'm not sure.
As you sit here today, you're not really sure whether it's coming from one of the other corporations that we discovered during discovery, or it's coming from you personally. Is that correct?
That's the answer.
I would like to answer. I'm going to have to invoke my 6th, 14th, and 5th Amendment rights.
And as it relates to any of the other witnesses who have had attorneys retained for them, is it also your response to invoke your 5th Amendment rights rather than to provide me with an answer as to who is paying the bill for those attorneys?
I'd like to answer those questions, but today my attorneys have asked me not to respond to any questions that may be relevant to this lawsuit. So I must follow their advice and invoke the 6th Amendment, 14th Amendment, and 5th Amendment right.
Have you interacted sexually with any underage minors in the last year while on house arrest or work release from jail?
Object. Argumentative and compound and lacks predicate.
I'd like to answer that question, but on the advice of counsel, at least today, they advised me I must invoke my 6th Amendment, 14th, and 5th Amendment right.
It's also overbroad.
If me narrowing it down would help you to respond, I will. Okay. Is there any need for that? No. Okay. Sorry. Is it your intent to interact sexually with minors in the future?
Same objection.
I'd like to answer that question. But today, my counsel has advised me I must invoke the rights of the 6th Amendment, the 14th Amendment, the 5th Amendment, and the U.S. Constitution.
Are you currently treating with a psychologist related to any sex addiction that you have with minors?
I'd like to answer that question as well as most of the other questions you asked me today. However, on the advice of counsel, they've asked me to invoke my 6th Amendment, 14th Amendment, and 5th Amendment right. Therefore, though I'd like to answer that question, as well as the other ones, I risk losing their representation if I do so.
And moreover, I'm objective relevance as I have in the past.
Okay.
Since medical history is not at issue in this case under the legal terms.
You would agree, wouldn't you, that you targeted these underage girls, including Tatum Miller, because of their young age?
Argumentative, speculative, harassing, and assumes facts, not evidence.
I would like to answer that question, as well as most of the other questions you asked me here today. My counsel has advised me that I must assert my 14th Amendment, 6th Amendment, and 5th Amendment right. Though I'd like to answer those questions today, if I do so, I risk losing their representation.
You would also agree, wouldn't you, that you targeted these underage females for sex, including because they were poor?
Same objections.
I'd like to answer that question. I'd really like to answer that question as well as the other questions you've asked me here today. However, on advice of my counsel, they've demanded that I assert my 5th Amendment, 6th Amendment, 14th Amendment rights, and if I answer that question, I risk losing their representation.
You would agree, wouldn't you, that you sexually molested for 3 years?
Same
Is that correct?
objection. Same objection.
I think you've asked me a question before, and I'll assert the same rights as before.
That's your 5th, 6th, and 14th Amendment, just so the record's clear.
Yeah.
You would agree, wouldn't you, that you coerced into prostitution?
Same objections.
I believe that her own testimony reflects, and at least the sworn statement to the FBI reflects that is not the case. And though I'd like to answer that question in great detail, I cannot do so today on advice of counsel that asked me to assert my 6th Amendment, 5th Amendment, and 14th Amendment rights. And if I do so, I risk losing their representation.
You would agree, wouldn't you, that you groomed into becoming a prostitute?
And object. Argumentative, speculative, certainly lacks predicate and assumes facts, not evidence.
You know I'd like to answer that question, but I can't today. And under advice of counsel, I'm going to have to assert my 14th Amendment, 6th Amendment, and 5th Amendment rights. If I answer the question, I risk losing their counsel.
You would agree, wouldn't you, that you brainwashed into believing that this lifestyle of prostitution was right?
Same objections.
I'd like to answer that question, as most of the other questions here today, Mr. On advice of counsel today, I'm going to have to assert my 5th Amendment, 6th Amendment, and 14th Amendment rights, because if I answer that question, I risk losing their representation.
Would you agree that your interaction with when she was a minor was degrading to her?
Same objections.
I'd like to answer that question. I'd like to answer all your questions here today. However, my counsel has advised me that I must assert my 14th Amendment rights, my 6th Amendment rights, and my 5th Amendment rights. And though I would like to answer those questions, if I do so, I risk losing their representation. Can we take a break of 10 minutes to get some air? Is that okay?
We have 15 minutes and we're done.
Oh, fine. No, stay.
Continue then?
Yep.
Okay. Would you agree that you intentionally indoctrinated into this very deviant sexual lifestyle.
Okay, I'm going to object. It's argumentative, it's confusing, it's speculative, vague, lacks predicate, assumes facts, not evidence.
And on top of that, I'd like to answer that question, but my counsel's advised me that I must assert my 14th Amendment, 6th Amendment, and 5th Amendment rights in the U.S. Constitution, though I'd like to answer all your questions here today. I cannot do so by risking losing their representation.
Would you agree that you were personally responsible for destroying her life?
Same exact objections.
Her life? I'd like to answer that question, and I understand how your firm has been accused of fabricating sexually charged lawsuits in order to fleece investors locally in South Florida. The U.S. Attorney has called a criminal enterprise based on filing fallacious sexually charged cases. And though I'd like to answer that question today, Mr. Counsel has told me that I have to assert my rights under the 6th Amendment, 5th Amendment, and 14th Amendment. And if I don't do so, I risk losing their representation.
We have a factual basis for asking every question and making every allegation, and I want to provide you with a last opportunity to tell the jury which of these allegations, if any, being made by Tyler are false or fabricated in any way.
Same objections. Mr. Edwards, you know the tenor of that question cannot be answered without waiver of 5th, 6th, and 14th. I appreciate the question and the semantics of it, but it's can you rephrase it?
Yeah, many times, you know the allegations now. We've gone through allegations and assertion of facts as to what happened between you and her when she was 13, 14, 15 years old, and you were 50, 51, 52 years old. And several times you responded saying something about or something about her FBI statement or what have you. And I want to give you a chance to tell the jury which of her allegations, if any, that you believe now are false or fabricated in any way.
Same objections.
I'd like to respond to that question. The fact that her firm, the law firm representing her, has been accused by the U.S. Attorney of being a criminal enterprise, manufacturing, fabricating out of thin air cases involving sexual allegations, in order to simply fleece local investors out of millions of dollars. So I would very much like to answer that question regarding the truthfulness of Ms. Tatum Miller's allegations. However, today, my counsel has told me that I must assert my 5th Amendment rights, 6th Amendment rights, and 7th Amendment rights under the U.S. Constitution, though I would very much like to answer those questions, but if I do, I risk losing their representation.
Would you agree that you owe at least $15 million to compensate her for the damage that you have caused?
No objection. Move to strike. Argumentative, compound, lacks substantial predicate, and assumes facts, not evidence.
As you might imagine, though your law firm has been accused of perpetrating a fraud involving millions and millions of dollars on unsuspecting investors here in South Florida, millions of dollars, by fabricating similar allegations, convincing people to give money to the firm that helped bring this lawsuit. I'm afraid I'd like to answer those questions, but no matter how much I'd like to answer those questions, I'm going to have to decline based on my counsel's advice to invoke, at least today, my 5th Amendment, 6th Amendment, and 14th Amendment rights of the U.S. Constitution. Because if I don't, I risk losing their representation.
Is it true that you are currently worth more than $1 billion personally?
I'd like to answer that question as I'd like to answer most of your other questions. I know that's a lot of money. It's actually the amount of money that the U.S. Attorney's accused your firm of trying to steal from the people of South Florida. It was $1.2 billion. The U.S. Attorney claimed your firm perpetrated the largest fraud in South Florida's history by stealing that sum of money from local investors based on false allegations of sexually charged claims. And so I'd like to answer these questions with specificity. I'm under advice of counsel today. I'm going to have to refuse based on my 6th Amendment, 14th Amendment, and 5th Amendment right. And though I'd like to answer the question, I've been told that if I do so, I risk losing their representation.
Great. I'm simply asking, what is your personal net worth at this time?
I think I've answered the question. But
what is your personal net worth at this time? So the answer should be a number, or should be you invoking your 5th Amendment rights? Seem like the options.
Well, that's an answer. He did invoke his 5th, 6th, and 14th.
His answer included something about stealing some certain amount of money, which obviously is non-responsive. I've moved to strike it, and I'd ask that he actually respond to the question with something that is responsive. His options are answer the question, you invoke your 5th Amendment rights. We get out of here.
it makes it sound very...
Let's start over again. Can you please tell the jury what your personal net worth is currently?
I'd like to do that today. However, I'm sure one of the reasons is since your firm has been accused of stealing millions of dollars from local investors based on totally fabricated claims. This is not by me, but by the U.S. Attorney. It's called your firm a criminal enterprise charged with stealing hundreds of millions of dollars, frankly, from local investors based on false claims of sexually charged nature. I'd like to answer that question in detail. However, my attorneys have advised me that I cannot answer any questions that may be relevant to this lawsuit. And by doing so, I must invoke my 6th Amendment, 5th Amendment, 14th Amendment right. And by answering the question, I risk losing their representation.
Okay, so is it true that you're worth $1.8 billion?
Same objection.
Same answer.
Go ahead and put the answer.
For the record, yeah.
For the record, I'm sure that's an interesting question, and I'd like to answer that question for you. I'm sure you'd like to know, as your firm has been charged with stealing over $1 billion from local investors, and your senior partner of both you and shaking his head, sits in jail, accused of fleecing local Florida investors based on false sexual claims from people. And though I'd like to answer that question like I'd answered most of your other questions, my counsel has advised me that today, ladies and gentlemen of the jury, I cannot answer that question. Maybe in the future. However, if I do so today, I risk losing that representation. So I must assert those rights under the 6th, 5th, and 14th Amendment.
You would agree, would you not, that it would take a jury award of at least $45 million in punitive damages to punish you for doing what you did to
Same objections.
I would like to answer that question as I'd like to answer all your other questions today. However, while he sits shaking his head, I'm going to have to respond to my counsel has advised me I cannot answer that question today, though I'd like to. Though I'd like to answer with specificity. However, if I do so, I risk losing that representation. So I must assert my rights under the 6th, 5th, and 14th Amendment.
Isn't it true, that as long as you have the money to do it, you will continue to engage in sex with minors?
Again, extremely argumentative, speculative. I'm allowing the questions to give leeway so I don't have to come back here again. It's harassing.
And with that, I'm sure this, ladies and gentlemen of the jury, will be able to see you and your partner, your firm has been accused of massive fraud in South Florida, trying to steal hundreds of millions of dollars from local investors, fabricating malicious, sexually charged claims, called by the U.S. Attorney a criminal enterprise, charged with money laundering conspiracy to commit other federal violations. So though I'd like to answer that question, I must invoke my 6th, 5th, and 14th Amendment rights advised by counsel or risk losing their representation.
And am I correct in my understanding that you have invoked your 5th Amendment rights because your answers would incriminate you and lead to your prosecution?
I'm gonna
Exactly as phrased by Mr. Ludier towards Tatum Miller. I did not say anything, but allowed her to answer the question.
Answer that question.
I'm gonna object to form.
In fact, since you are a lawyer, I'm sure you're aware the Supreme Court has said that the 5th Amendment is used more often to protect innocent people. So that's, it's today the advice of counsel that I've taken that right.
I have no question.
No further questions.
Going off the video record at 3:52 p.m.